Yeah, we are Newsroom. Hello and welcome from Johannesburg, here in South Africa. My name, of course, Evan Jansen. The show is always live and broadcast from our studios right here in Auckland Park. Don't forget, between 9 and 12 every weekday morning, we are live on YouTube as well. We've got a streaming facility there. You can watch us back on demand on that same channel later in the day. Well, today we've got a question, and there's only one question on all of South Africa's lips today. We want to know what you think. 5 judges will decide Oscar Pistorius' fate in the Supreme Court of Appeal in Bloemfontein. Our question is, should Oscar go back to jail today? At SABC Newsroom, that's where you can send us your contribution, or you can go to our Facebook page. But first, there's some more news. Lots going on in South Africa right now. Elvis gives us an update.
Thank you, Evan, and let's take it from the top. It's D-Day for Oscar Pistorius, as he will find out today if he will return to jail or not for killing his girlfriend Riva Steenkamp on Valentine's Day in 2013. South Africa and China have signed 26 agreements valued at 94 billion rand following a meeting between the President Jacob Zuma and his Chinese counterpart Xi Jinping in Pretoria yesterday. 14 people have been shot and killed and 17 wounded in San Bernardino in California in the U.S. when 3 gunmen opened fire during a holiday party at a social services agency for the disabled. Those are all your headlines, but before we do get there, let's find out from Kendall Makamate what is happening on the sports front. A very good morning to you, Kendall.
Good morning, Elvis, and hearty good morning to you at home as well. This is what we've got for you in the sports today. Now, having already lost the series, the Proteas have nothing to lose in Delhi as they face India for the last time before heading back home.
It just drifted a little bit in the air.
And the HSBC 7 Series Open is almost upon us as the Blitzbokker put the finishing touches in their title defence. Of course, Algeria were too strong for Mali last night in the Under-23 AFCON, winning by 2-0.
Who was loitering with intent at the far post, offering Algeria.
And that's what we've got for you in the sports at 10:20 or so. Back to you, Elvis.
Thank you, Kendall. Our top story this morning. 5 judges will give their verdict on the future of Oscar Pistorius in the Supreme Court of Appeal in Bloemfontein this morning. He was found guilty on a charge of culpable homicide for killing his girlfriend Riva Steenkamp and spent 10 months in jail. But the state has appealed, arguing that he's been convicted, that he should be convicted, rather, of murder.
This is the cell where Oscar Pistorius was jailed. And now, a decision is imminent on whether the athlete will return here. That decision lies in the hands of this panel of judges. Last month, the prosecutors argued why the athlete's conviction should be overturned to murder. At the center of their argument, that the trial judge misinterpreted the law.
The court erred in the evaluation of the principles of dolus eventualis by not evaluating the evidence, taking into account 3 things. The principles of dolus eventualis, a possible defense of period of private defense, and error objector. The court just wanted to apply the principles of dolus eventualis in isolation without taking the other 2 into account.
But the defense, relentless, defended Masipa's decision, arguing that she applied all the evidence to the law correctly.
It's an objective fact. He's scared. He's really scared. He believes the deceased is in the bedroom because he'd spoken to her before. When he woke up, he'd spoken to her. So it's not that he believed she was sleeping there. He knew she was awake, but he knew she was in the bedroom. That's the finding. Now he fires. If it's not for that reason, and one tries to sit back and think, why did this man then fire the shots? There is no reason other than to accept the state's case, which cannot be, because it's inconsistent with the probabilities.
But the judges did not seem convinced.
Was there anything that showed, apart from a noise, that his life was in danger? Or that he honestly believed that his life was in danger?
Well,
I know we live in times where people break into your houses and things of violence, but This is a person in a small area. He's armed with a firearm. He went to confront the noise, armed himself, went to confront the noise. And then, indeed, what happens? There's a noise, and then he shoots it.
Over the past few weeks, Pistorius has been under house arrest at his uncle's home. And he's also kept a very low profile. But a recent picture posted by a family member shows him in good spirits on his birthday. As the focus returns to Bloemfontein, the proceedings are expected to last just a few minutes. Well, Justice Eric Leach will read out a summary of the judgment, which will seal the fate of Oscar Pistorius once and for all. Criselda Lewis, SABC News in Johannesburg.
Now, for the latest on the expected ruling, we cross now live to a reporter in Bloemfontein, and a very good morning to you, Mangoban Kunu.
Good morning, Elvis.
Can you set the scene for us, please? What is about to happen this morning?
Well, certainly, Elvis, today is D-Day for Oscar Pistorius, as we'll finally know his fate by the end of the day today. And certainly, we know this will be a game changer for the athlete, as this decision could decide whether he does go back to jail or whether he continues to serve the rest of his sentence at home under house arrest. Now, definitely a lot is at stake here for both the defense and the state. We know that the state has always argued that it believes that Oscar Pistorius got off lightly for killing River Steenkamp, saying that it believes that Judge Thokozile Masipa erred in reaching that verdict of culpable homicide, insisting that Oscar Pistorius should have been found guilty of murder initially, saying that Judge Thokozile Masipa erred in an interpretation of the law with regards to that principle of dolus eventualis. And really, Elvis, that's what's been at the center of this legal battle, as to whether the judge did correctly apply the factual findings of this case with according to that principle of dolus eventualis. And what really dolus eventualis refers to, if we break it down, the word dolus in legal terms means an intent to do something. And when we look at dolus, there are two types of doluses. Firstly, the first one being dolus directus. And what dolus directus means is direct intent to do something. And in this particular matter, did Oscar Pistorius foresee that, River Steenkamp was in the toilet? Did he know that when he fired those 4 shots, he was shooting at River Steenkamp? And indeed, if he did, this means that he had direct intent to kill River Steenkamp. On the other hand, there is then this principle of dolus eventualis, which basically means indirect intent. And basically, in this matter, this would mean that Oscar Pistorius foresaw the possibility of shooting and killing somebody, whoever was behind that door that morning, but still continued to fire those 4 shots. And this is really what the state is saying that Oscar Pistorius did foresee that by firing through a small cubicle, that the person inside could have been killed, and therefore he is guilty of killing indirectly or dolus eventualis. And certainly this will bring about clarity as to whether Judge Thokozile Masipa did apply this correctly in reaching her verdict of culpable homicide. Now, the defense, on the other hand, is saying that they believe that the state is just simply trying to resurrect its failed case of premeditated murder, saying that really they believe that Judge Thokozile Masipa correctly applied the factual findings to the law, and that she was correct in reaching that particular verdict. But whether they've done enough to convince the judges here at the Supreme Court of Appeal remains to be seen when that judgment is delivered in about a few minutes from now. But certainly this will be a game changer in this particular trial.
Thank you so much. That was our reporter in Bloemfontein, Mangoba Mkunu, this morning. He'll keep us updated on that ruling a little bit later. We might be crossing there live a little bit later, so you have to stay tuned. Do not touch that remote. Well, that's all we have for you for now. Let's now take a look at the Chinese President Xi Jinping, who has kicked off his official state visit to South Africa. The Chinese head of state touched down in South Africa yesterday following a visit to Zimbabwe. President Jacob Zuma and his cabinet will be looking to shift the focus from exploration of natural resources by China to beneficiation, which will be advantageous to South Africa.
The traditional pomp and ceremony to welcome South Africa's single largest trading partner. President Jacob Zuma welcomes his Chinese counterpart Xi Jinping to the nation's capital. Both countries share a long history of cooperation, dating back to China's support for the ANC during the anti-apartheid liberation struggle. President Xi Jinping had brought a high-level delegation of business people and cabinet ministers. President Zuma says South Africa is looking for equitable trade relations with China.
We focused on especially our economic and trade relations. We have just witnessed the signing of 26 agreements that are worth 94 billion rand.
China's president says both nations stand to benefit from strengthened economic relations.
We share the view that the two sides should continue to view and promote China-South Africa relations from strategic and long-term perspectives. We need to maintain close high-level exchanges, strengthen the sharing of governance experience, and also on issues concerning our major concerns, we should extend mutual understanding and support.
President Zuma says there is a need for the international community to work in solidarity to condemn global terror attacks that are attempting to shake various economies. President Zuma visited China in December 2014. At that time, the two leaders concluded the 5 to 10-year strategic program for cooperation between South Africa and the People's Republic of China. Both nations will also look at increasing marine cooperation, infrastructure development, and human resources cooperation.
14 people have been shot and killed and 17 wounded in San Bernardino in California in the U.S. Police say 3 gunmen opened fire during a holiday party at a social services agency for the disabled. Police say the suspects were armed with rifles. They are believed to have made their getaway in a dark sport utility vehicle. Later, during a shootout with the police, a man and a woman suspected of taking part in the massacre were killed. The motive for the shooting is not yet known. There have been more than 350 shooting incidents in the U.S. this year alone. The United Kingdom House of Commons has voted overwhelmingly to authorize the airstrikes in Syria after more than 10 hours of debate. In the end, 397 MPs, including 67 from the opposition Labour Party, voted to support the Prime Minister David Cameron's 12-point plan aimed at destroying the so-called Islamic State in Syria. 223 lawmakers voted against the plan.
Anti-war demonstrators gathered yet again in Westminster to urge MPs to vote against bombing Syria. But in the end, a motion to extend airstrikes passed comfortably. The day-long debate began with Prime Minister David Cameron making an impassioned plea for the UK to take the fight to the extremists with an aerial campaign, however without any British soldiers on the ground.
The House should be under no illusion. These terrorists are plotting to kill us and to radicalise our children right now. They attack us because of who we are, not because of what we do.
But many were opposed. Labour leader Jeremy Corbyn criticised David Cameron for what he called a rush to war, wanting instead more action on a political solution. And he questioned government claims that up to 70,000 ground troops were available in Syria to work with the UK, once IS forces had been depleted.
The only ground forces able to take advantage of a successful anti-ISIL air campaign are stronger jihadist and Salafist groups close to the ISIL-controlled areas. I think these are serious issues that we need to think through very carefully.
The vote came just 19 days after multiple Islamic State terrorist attacks in Paris left 130 people dead. The incident dramatically changed the mood in Westminster as well as in the wider public and handed David Cameron the votes he needed.
He's got the mandate that he wanted, but it's a big gamble, and if it doesn't work the way he's predicted, if this big international force isn't able to decisively turn the tide against IS, he's going to have some really difficult questions to answer.
The move will be particularly welcomed by the US and France, whose existing bombing raids reportedly rely heavily on UK drone intelligence. David Cameron also argued Britain's precision missiles will help the coalition reduce civilian casualties. In the end, despite the protest, the motion passed. Now the UK is set to enter a military conflict in the most complex of circumstances. David Cameron has won the argument for now, but there are daunting challenges ahead. Catherine Drew, SABC News, London.
Here at home, the EFF leader Julius Malema is rubbishing Nelson Mandela's legacy and is being driven by a desire to get votes in next year's local government elections. Now, that's the view of Mandela's lawyer and old friend George Bezos and the Gauteng Premier David Makhura. The two were reflecting on the state of the nation a few days before the anniversary of Nelson Mandela's death. A few days ago, Mandela told a public gathering in the United Kingdom that Mandela had begun to sell out the revolution by deviating from the Freedom Charter. He went on to say that the former president stayed in a house of rich white men and was looked after by the Oppenheimers.
I'm very concerned that there is a small, ignorant minority who has the cheek to say that Nelson Mandela betrayed the black people in South Africa. This young man and the other small group of people who actually tried to belittle the heritage of Nelson Mandela should be ashamed of themselves.
It can be very easy for somebody who doesn't understand what it really took to bring our country from the precipice of civil war. Probably maybe someone was too young or was just far from the events, forgivable. When armed struggle was suspended, we opposed it. We didn't want, we wanted to continue the war. We opposed the idea that we must settle with the enemy, peaceful negotiations. But through dialogue and conversation, we understood why that was a wise thing.
Meanwhile, the EFF leader Julius Malema has lashed out at the media following recent headlines over statements that he made while on a tour in the UK. He said that he was misquoted in reports of him singling out the former president, Nelson Mandela, as having abandoned the Freedom Charter. Malema was speaking at a media briefing on his UK tour and the party's achievements in 2015.
Julius Malema's trip to the UK, a trip that sparked controversy. But Malema says the media distorted his remarks during his tour. Today, Malema said Mandela had abandoned some principles of the Freedom Charter, but that the failure to implement them was collective.
I don't believe Mandela sold out. I believe Mandela made his contribution to a particular extent, and it is up to us to take it from there and move forward.
Today, the party reflected on all its 2015 programs and reiterated the party's decision to occupy the offices of one of the leading South African banks next year. Malema says the aim is to send a message that transformation in the banking sector is one of the party's priorities. SABC News, Johannesburg.
Non-governmental organization Gift of the Givers has received proof that Stephen McGowan, a South African man taken hostage in Mali in 2011, is still alive. McGowan was taken captive from a Timbuktu hotel in November 2011 together with the Swede national Johan Gustafsson. The McGowan family hope that their son will be home for Christmas.
My name is Stephen McGowan. I'm a South African citizen. Today's date is Tuesday the 20th of October 2015. Short message to the South African government. I thank you for your continued efforts in negotiating my release. My wife and my family, I am well. I hope you are all well back home. I understand that I may be seeing you soon. I believe that there is an organization involved now, a South African organization involved, brokering the release. I thank this organization. I thank this organization for everything, for bringing this to a close and having me home soon. I thank you. The protracted strike by trade union AHAO in Parliament has ended.
The union has accepted the latest offer on the payment of outstanding performance bonuses.
Despite interdicts, a heavy police presence or even the weather, every day for more than 3 weeks now, striking workers stood united in making their demands heard in and around the parliamentary precinct. But acceptance of the new percentage calculation for performance bonuses applies only to the 2014-2015 financial year and comes with 2 non-negotiable conditions.
No employee should be victimized for having participated in protest or in striking. Number 2, we say those deductions, illegal deductions, that were made on our salaries without following Section 34 of the Basic Conditions of Employment Act should be reimbursed with immediate effect.
Tembe says the compromise was reached by Nahau's national leadership and Parliament's presiding officers, following what the union has described as a breakdown in their relationship with Parliament's management.
So in future, when we have similar challenges, we want the nation to understand that is because of the management of Parliament. We are willing to work with them, provided they change.
Nahau vows that the struggle is not quite over yet. They say in 2016 workers will continue their struggle for better working conditions in Parliament, including the demand for consultation on security vetting and an end to outsourcing. Parliament says it will respond in due course. Esli Philander, SABC News, Cape Town.
The Johannesburg Environment and Infrastructure Mayoral Committee says there's an urgent need for a solution to the strike at waste management company Pick It Up. The company's workers, who are members of the trade union SAMU, embarked on an unprotected strike more than a week ago. The strike has affected refuse collection in the city. Committee member Tsadiso Mfikwe says that they are engaging SAMU workers or leaders. Pick It Up has also condemned the violence by the striking SAMU members.
A world-class city brought to its knees. And this is why the situation here fast becoming a hazardous one in more ways than one. It's very dirty and smelly. We are even scared that we might fall sick from diseases like cholera.
It's very dirty here in Johannesburg. We battle to do anything.
In some suburban areas, similar scenes, the situation reaching crisis level. But in the midst of the chaos, some are benefiting from the strike. This man collects recyclable material. As the waste piles up, the stench is fast becoming unbearable. Pick It Up says contingency plans will hopefully bring some relief. It says red ants and private companies have now been deployed to help clear the waste, but they've already been targeted by striking SAMU members.
They're raising their own issues now that the strike is degenerating into violent behavior. I think is uncalled for, and it is a despicable act.
SAMU now plans to intensify its action, calling on waste workers from Tshwane and Eguruleni to join the strike. Angoba Mchunu, SABC News, Johannesburg.
Now, the fate of Oscar Pistorius will be decided by the Supreme Court of Appeal in Bloemfontein today on whether he should have been found guilty of culpable homicide or murder by Judge Masipa. Justice Eric Leach is expected to read the summary of the judgment today. Now, let's just take a look at some of your comments on our Facebook page and on our Twitter page. Remember to send your views on Twitter at SABC Newsroom. The first one here from Tsidin Koko says, I'm looking forward to this Oscar appeal ruling. This one from Sobahle says, I'll be furious if Oscar Pistorius' parole gets extended regarding today's outcome. If he's found guilty of murder, he should rot in jail. So says Sobahle. Nompi says, Oscar Pistorius should have just been honest. Now he gets to face himself again. And we all know he can't do that. This one from Madeleine says, been up since 2:30ish a.m. Wednesday and trying to stay awake until 2:45 a.m. for Oscar Pistorius' decision. My disposition will be stellar, says Madeleine. Well, let's see if there's also some live pictures here. We'll see if we can get some live pictures. As you can see, they're in court already, waiting for the verdict that's going to happen today. It is D-Day for Oscar Pistorius today, and we'll cross live there to give you the latest on that verdict coming from Judge Leach. 5 judges will be sitting for this particular verdict. So you have to stay tuned. Absolutely thrilling. We'll also find out a little bit more what's happening at courtside from our reporters on the scene. There is the families sitting already waiting for that verdict. Now, today's picture of the day comes from Reza, and it's captioned Fire. Denver squatter camp, Johannesburg, dozens of shacks already destroyed. In fact, that was yesterday's picture. We'll see if we can find you the picture of today. This one here looks at dirt in the city. That is all dirt in the city there. As you can see, as you know, Pick It Up is on a strike, and it's been going on for a while now. The streets here in Johannesburg is absolutely filthy. I was driving through town yesterday, and I can tell you the stench in the city centre, unbearable. And here in Johannesburg, we don't know if they ever going to reach a compromise in terms of what is happening there. So let's now take a look at some of the front pages of the newspapers from around the globe. And let's start off in Europe. The Times report a man and a woman suspected of killing 14 people at a center for the disabled in California have been shot dead by police after a huge manhunt. There you can see the picture there. And then moving to Jerusalem, the Jerusalem Post says that the home belonging to the terrorist ringleader responsible for killing a Jewish couple in the West Bank in early October was bombed this morning. And finally then, in China, the South China Morning Post reports that President Xi Jinping on Monday called on leaders from more than 140 countries to abandon the zero-sum mindset on climate change and unite to tackle the common challenge. These are all your newspapers that we have for you this morning. Let's take a break, and we'll be right back after that.
Defied family and traditions to follow her dream.
Decided that I'm going to prove to them that they were wrong.
The first breakthrough came in when she was studying and touring in Europe.
That was my first breakthrough.
Generations was her first television debut in South Africa.
It was my first gig. I was very excited. I was very happy. I said, yeah, this is confirmation I'm at the right place.
After pain, rejection, and suffering, her dream became a reality.
I followed my path, and I'm happy and grateful and blessed.
Join your host, William Mulabati, on Rupilong every Friday at 17:30.
Welcome back. You're still with Newsroom. Now we're counting down till about 10 o'clock when the Supreme Court of Appeal here in South Africa will be ruling on Oscar Pistorius' fate. Their 5 judges will decide whether he'll be going back to prison. Of course, our question of the day relates directly to that. We're asking you, should Oscar Pistorius go back to prison? There's the question on screen. We'd love you to interact with us at SABC Newsroom is where you can send your contribution. We'll put it up a little bit later in the show as we go live. After we go live, we would love to have a discussion forum around that. But we move on now as we count down the minutes to that ruling with the holiday season fast approaching, and given the country's appalling annual road death statistics, we're constantly reminded of South Africa's high rate of drunk driving-related deaths. Now, according to the World Health Organization, South Africa tops the list of drunk driving-related deaths on the planet. The latest global status report on road safety for 2015 reveals that 58% of deaths on the roads in this country are alcohol-related. Very concerning. For more on the story, we are joined via Skype by Dr. Etienne Krug, who is the Director in the Department for the Management of Non-Communicable Diseases, Disability, Violence and Injury Prevention at the World Health Organization headquarters in Geneva. Very good morning to you, Dr. Krug. Thank you for joining us.
Good morning. Thanks for having me.
As you can understand, in South Africa, we are very concerned that we're topping the list of the world's drunk drivers. Tell us a little bit about the outcomes of your report.
Well, the report shows us that the road safety situation is bad around the world. We need to do more. Somehow we have arrived at a situation where we have a transportation system that kills 1,250,000 people every year and injures up to 50 million. It's a huge toll in terms of human life and also economic costs. And we're just accepting it without suddenly shaking up and saying we have to do something about this.
You mentioned the economic cost, the burden on society that this has. Can you kind of give us a global picture of this economic burden you're talking about?
Well, there's a huge cost in terms of injuries, death, because we often talk about young people here. It's actually road traffic crashes have become the leading killer of youth around the world, the #1 cause of death. And these are fathers and mothers, the breadwinners of families. So they throw families into poverty every time there is a crash like that, seriously injuring or killing the breadwinner of the family. But if you add it all up at the national level, we're talking about 3 to 5% of the gross domestic product of a country. It's a huge economic toll, particularly when we're looking at Africa.
Tell us a little bit more about Africa. We understand few reports have now pointed out that the roads on the African continent are the most dangerous in the world.
Well, we're seeing a rapid transformation in Africa with more roads, more cars on the road, new drivers taking the road, which to a certain extent is good, it's development, but it is not accompanied with the necessary safety measures. Right now, we see the highest road traffic death rates in the world in Africa, while at the same time, it's the region where we have the lowest number of vehicles. So there's a huge mismatch there, and we need to do more. We don't need to accept that the price of development is going to be death and injury and disability. We can do something about this. We have experience from countries that have managed to avoid such disasters, and we have to put in place the laws, the enforcement, the vehicle standards, and the infrastructure measures that will avoid this disaster.
Coming back to drink driving, it's a particularly important risk factor here in South Africa, as the report notes. What do you think should be the best way for South Africa to deal with the problem of drink driving?
Well, drink driving is unacceptable. It puts people at risk, those who are in the car, the driver himself or herself, the people, passengers in the car, as well as pedestrians and people who cycle or other people in other cars on the road. So it's really putting a lot of people at risk, and it can be tackled. South Africa has actually a good drink driving law, which is the first step. We need good legislation, and South Africa has a good law on drinking and driving. Where we need to do more is in the area of enforcement. A law on paper is not enough. We need the police out there to do random breath testing. We need to enforce the law that exists, and we need to educate the public. We need to make people aware that it is wrong to drink and drive, that it is dangerous and that it kills people, and that those who do it will end up with the consequences, either fines or even prison.
Very sobering thought. I thank you very much for joining us today. That is Dr. Etienne Krug. He's the Director in the Department for the Management of Non-Communicable Diseases, Disability, Violence and Injury Prevention at the World Health Organization. He came to us live from Geneva this morning. Of course, right here in South Africa, we're counting down the minutes to this landmark ruling in the Supreme Court of Appeal of the Oscar Pistorius trial. Now, I can tell you that there have been many arrivals in Bloemfontein this morning. There you see live pictures coming in from courtside. That's June Steenkamp. June Steenkamp has been very vocal in recent times about her feelings towards Oscar Pistorius. She's pointed out in an exclusive interview with us here at SABC News that she holds no grudges against Oscar Pistorius. She has no feelings towards him. She's now focused her her attention, rather, to the Reeva Steenkamp Foundation, a foundation that will deal with with violence against women, specifically women and children. Of course, here in South Africa right now, we are in the middle of the 16 days campaign of violence against women and children. Now, our man on the scene outside courtside is Manqoba Mqunu. A very good morning to you, Manqoba. Just understand you've got the Women's League with you there. They of course, have been very vocal in this instance. Coincidental that it's also coinciding with the 16 days campaign.
Well, certainly, Eben, we're just a few moments now from finding out what the court or the Supreme Court of Appeal will decide with regards to the Oscar Pistorius appeal. We know that this is certainly going to be a game changer for the athlete, as it will decide whether he does go back to jail or whether he continues to serve the rest of his sentence under correctional supervision. As you've correctly said, June Steenkamp just walked into court just a few moments ago, flanked by some of the family members from the Steenkamp family. We do know that for a fact that Oscar Pistorius' family will not be in court today. They've indicated that they are going to issue a statement after consulting with their legal team. But certainly the Women's League, the ANC Women's League, has been at the forefront supporting the Steenkamp family since day one. We saw them during the trial in Pretoria. They've been with June Steenkamp the whole way. And I'm going to be speaking right now to Mamu Oli Mlamleli, who is from the ANC Women's League. Mamu Oli, first of all, just to find out, you've been there throughout. What do you expect from the court today?
Today we are expecting the judgment to say that Oscar Pistorius must go back to jail. We are here to support Reeva's family. I've just given a hug to her mom to say, we are here to support you. Your pain is the pain of the ANC Women's League, is the pain of all women in the country, is the pain of all women in this province of the Free State. We are also here to say to women in this country, let us stand together. Together we can do more to ensure that we fight against this violence against women and children. We are calling upon all women to fight against these horrific deaths that are done. The women are dying day in and day out. Children are being molested. It's only yesterday when I was in Kwakwa where we found a case of a man who was trying to kill a child. But today we are here as all women of the Women's League and supported by all women in this region, supported by all women in the country. Others are calling to say they are here with us spiritually. So we say today we are supporting NPA to say Oscar Pistorius must go back to jail and he must go for appropriate price for what he has done. We are saying again today, Reeva did not deserve to die in this manner. We still wanted to be with her because she was at the height of her career. Then he decided to cut her career. We are saying to Reeva, we still love you and may her soul rest in peace.
Okay, Mama, you also spoke to the fact that you've obviously hugged June Steenkamp, but do you have a sense of how she feels today?
I think my sense of how she feels today is that she wants to see Steenkamp, Oscar Pistorius, going back to jail. But as a mom, I think, and also as a Christian, she has accepted that Reeva is no more, but she would like to see justice being done.
Thank you very much. That was Mamu Oli Mlamleli, who is part of the ANC Women's League members that are here in court today supporting the Steenkamp family. And certainly we're expecting urban proceedings today to be very brief, as one of the justices is expected only to read a summary of the full verdict. And certainly it will clarify once and for all whether that principle of dolus eventualis was correct. And it will certainly also say whether indeed Oscar Pistorius will go back to jail or whether he'll continue his sentence under house arrest.
Manqoba, before I let you go, I see that June Steenkamp is there. Just tell us about the arrivals there this morning. Have you seen any of the Pistorius family, for instance, at courtside, or are they not?
Well, Eben, we haven't seen any of the Pistorius family members in court. They did indicate to us yesterday through a media statement that they will not be attending court proceedings. They did also say that they won't be giving any statements or any formal statements on camera following the judgment here in court. But they did say that they'll try to issue some sort of a statement, a written statement, after consulting with their legal team. And certainly so, we're not expecting them in court. We also haven't seen the two advocates that have been in the front of this legal battle, that is the state prosecutor Kherinal, as well as the defense attorney advocate Berry Roo. So they have been represented also by members of their particular companies who are here in court. So certainly we know that for sure the Pistorius family will not be in court, and we know that certainly June Steenkamp will certainly try to speak to the Steenkamp family, but we're also not hoping too much with regards to that, as we know that this could be an emotional time for the family.
Thank you very much, Mangoba, for that update. Of course, we're counting down to what will be happening in the Supreme Court of Appeal. There's lots happening around the country today. Of course, Prince Harry will also be meeting with Jacob Zuma, the President of South Africa, in about 20 minutes' time. We'll try and get all of those and kind of mix and match it in here today, try and keep you up to date. The forum on China-Africa cooperation also kicks off a little bit later today. Yesterday, South Africa and China signed 90 billion rands worth of deals in 26 agreements that they've put together. Now, let's just have a look at some of the comments that have been coming in after the deals that we've seen come up. Tembani talks about great example of South versus South relations in the West. Don't like it. Talk about China-SA state visit. Malawi says the biggest trade must happen between each other, Africans. We will never recolonize each other, says Malawi. 94 billion rand, and now Chinese language to be included in SA. I don't know. One shouldn't always see the end of the world. It is a choice in schools to learn Chinese. When we learned French, it was not a problem. When we learned German, it was never a problem. Why should it be when we learn a little bit of Chinese, Mandarin, Cantonese in our schools? Anyhow, we'll take a short break. When we come back, Elvis will pick up a very interesting scenario ahead of the holiday season. Do you have travel insurance? What does it mean? Don't go away.
It is important for everyone to know food safety practices and make sure that their food is prepared safely from farm to the plate.
Who ensures that there's compliance?
In terms of all the abattoirs, they have to be registered. So when they are being registered, they are actually audited fully to make sure that the structural requirements as well as the hygiene requirements are met.
Most bacteria and viruses cannot withstand the normal cooking temperatures that we use to cook our food.
The bigger retailers cannot be seen as being insensitive to the food safety requirements.
There are many consumers that actually go shopping with a cooler box and ice packs so that they don't break the cold chain, because a few hours outside the temperature that it should be already shortens the shelf life of that product.
Join me on Health Talk every Saturday morning between 9 a.m. and 10 a.m. as we unpack current health stories.
Welcome back. Now, it's that time of the year again when you plan to go on holidays in different locations to enjoy the festive season. Now, some are planning to enjoy the holiday season locally, while others will travel abroad. But apart from planning process, many may have forgotten to ensure that they are covered for financial losses caused by unintentional interrupted travel plans or medical emergencies while traveling abroad. Now, this could be avoided if you have travel insurance. Now, to tell us more about travel insurance, we are now joined by Dave Honeyman, the Executive Head of Stalker Hutchison Admiral, or SHA, as he normally says. A very good morning to you, Dave, and welcome.
Hi, Elvis.
First and foremostly, just for those who forgot, what is travel insurance again?
Travel insurance is your peace of mind when you leave the borders of South Africa, making sure that you have adequate insurances for you and your family in the event that something goes wrong. So effectively, it's there to make sure that if any medical situations might happen, that you would be insured for those, or if you're in need of any urgent advice or any assistance whilst you're overseas in a foreign country, that you have people behind the scenes that are there to help you and your family through any difficult situations.
Now, unfortunately, we got to leave it there, but if somebody wants to get in touch with you or to get insurance, how do they do that?
They can contact us at www.sha.co.za or TRC, Travel Insurance Consultants.
That's Dave Hutchison, the Executive Head of Stalker Hutchison Admiral. Unfortunately, we've got to cut that interview. Oscar Pistorius, the trial is happening, and as we speak, let's go to the court live.
February 2013, the respondent, Mr. Oscar Pistorius, shot and killed the 29-year-old Ms. Riva Steenkamp at his home in a secured complex known as Silverwoods Country Estate in the district of Pretoria. Pursuant to this, he was tried in the Gauteng Division of the High Court, Pretoria, on several charges, including one of the murder of Ms. Steenkamp. Throughout the proceedings in the trial court, the respondent was referred to as the accused, and for convenience, I intend to do so as well in this judgment. I trust that those near and dear to her will forgive me if I refer to Ms. Steenkamp at times by her given name of Riva, although I shall endeavour to do so only where it is necessary to emphasise her identity. I shall refer to her otherwise simply as the deceased. The proceedings in the trial court were attended by unprecedented publicity. As far as I am aware, for the first time in the history of this country, a trial was covered on live television, as was the appeal which followed in this court. Although I did not follow the proceedings closely, it was impossible not to learn that although it was common cause that the accused had shot and killed the deceased, the trial court had found him not guilty of her murder, but guilty of culpable homicide. Contending that the trial court erred on certain legal issues, the Director of Public Prosecutions, with leave of the trial court, now appeals to this court on questions of law reserved, arguing that the appropriate conviction would be one of murder. It is necessary at the outset to clear a technical issue out of the way. The appeal to this court relates solely to count one of the indictment, namely the alleged murder of the deceased. The accused was not charged in the alternative with a lesser offence of culpable homicide. It was unnecessary for the state to do so, as Section 258 of the Criminal Procedure Act, 51 of 1977, the CPA, provides that if the evidence led on the charge of murder does not prove that offence, but the offence of culpable homicide, or numerous other offences unnecessary to mention for present purposes, the accused may be found guilty of the offences so proved. That is what happened in the present case. The trial court held that the state had not proved that the accused was guilty of murder, but had shown that he was guilty of culpable homicide. Relying on Section 258, it accordingly found him guilty of the latter offence. The appeal to this court relating to this conviction is brought in respect of questions of law reserved under Section 319 of the CPA. I interpose to mention at this stage that from then on I proceed to deal with the technical point of whether, in the light of the accused having been convicted on a competent verdict, there could be an appeal to this court as a question of law. The issue revolves around a previous decision of this court in a matter called Siekwe. We have dealt with the matter, and it's not necessary for present purposes to repeat what we said there. But in conclusion, I return to say that in the light of this, counsel for the accused accepted that the limitation upon the state's right of appeal on a point of law as prescribed in Siekwe could no longer be regarded as good law, and that there could be no objection to the appeal proceeding in respect of the points of law reserved in the trial court, notwithstanding the conviction of the accused on the competent verdict of culpable homicide. This concession was properly made. In the light of this, I turn to the issues raised in the appeal. In order to do so, it is necessary to paint the factual backdrop to the points of law debated before us. I then proceed to briefly summarize the accused's physical disabilities and how he, despite that, he became a celebrity in world athletics. And I continue as follows. The accused met the deceased on the 4th of November 2012 when they were separately invited by a mutual friend to lunch at a motorcar track day event. She agreed to accompany him to the South African Sports Awards function that evening. Romance quickly blossomed and they became intimate. As so often happens with romantic relationships, especially in their youthful stages, theirs was attended by petty conflict and tensions, as is evidenced by a transcript of text messages that had passed between them that was handed as an exhibit at the trial. But despite these hiccups, the deceased at times slept over at the accused's home. She did so on the night of the 13th of February 2014. In the early hours of the following morning, screams, gunshots, loud noises and cries for help were heard emanating from the accused's house. Within minutes, a Mr. Stander and a Dr. Stipp, the latter a medical practitioner, arrived at the accused's home. There they found the accused in a highly emotional state, kneeling alongside the deceased, who was lying on the floor at the foot of the stairs leading to the sleeping quarters of the house. She had been carried there by the accused from an upstairs bathroom where the shooting had taken place. She had been shot several times and was mortally injured. The severity of her injuries was such that she was not breathing, and Dr. Stipp was unable to find a pulse. If she was still alive at that time, she died soon after. In due course, the accused was charged with her murder in the Pretoria High Court. It was common cause at his trial that the accused was responsible for the death of the deceased and that he had fatally injured her when he fired 4 shots with a 9mm pistol through the door of a toilet cubicle in the bathroom adjacent to his bedroom. Relying upon a web of circumstantial evidence, including the screams that had been heard before the sounds of the shots that the accused had fired, the state attempted to persuade the trial court that the accused had threatened the deceased during the course of an argument, that she had locked herself into the toilet cubicle in the bathroom to escape from him, and that he had thereupon fired the fatal shots through the door and killed her. The accused, on the other hand, alleged that he had awoken from his sleep in the early hours of the morning. It was very warm, and when he sat up, he noticed that 2 fans he had earlier positioned near the sliding door in the room leading onto a balcony were still running, and the door was still open. Although it was dark in the room, he was aware that the deceased was awake in the bed next to him as she rolled over and spoke to him. He got out of bed, brought the 2 fans into the room, closed and locked the sliding doors, and drew the curtains. It was very dark in the room, the only light being from a small LED on an amplifier at the television cabinet. He noticed a pair of jeans lying on the floor and had just picked them up in order to place them over the amplifier to cover the light when he heard the sound of a window opening in the bathroom. The bathroom is situated not directly adjacent to the bedroom, but down a short passage lined with cupboards. He immediately thought that there was an intruder who had entered the house through the bathroom window, possibly by climbing up a ladder. He quickly moved back to his bed and grabbed his 9mm pistol from where he kept it under the bed. As he did so, he whispered to Reva to get down and phone the police before proceeding to the passage leading to the bathroom. He was not wearing his prosthetic legs at that stage and, overcome with fear, he started screaming and shouting, both for the intruder to get out of his house and for Reva to get down on the floor and to phone the police. When he reached the entrance to the bathroom, he stopped shouting as he was worried that the intruder would know exactly where he was. As he neared the bathroom, he heard the toilet door slam. Photographs of the bathroom showed that facing the passageway entrance, there's a shower cubicle immediately adjacent to a toilet cubicle, the latter having an external window. The toilet cubicle is fitted with a door and is very small. Also in the bathroom is a triangular built-in corner bath immediately to the left as one enters. According to the accused, he had his pistol raised in a firing position with his arm extended ahead of him. Peering around the wall at the end of the passageway, he saw that there was no one in the bathroom itself, but that the toilet door was closed. He alleged that at that point he started screaming again, telling Riva, who he presumed was in the bedroom, to phone the police. He then heard a noise coming from inside the toilet and promptly fired 4 shots at the door. After that, he retreated to the bedroom where he found that Riva was no longer there. It then dawned on him that it could be her in the toilet. In panic, he went back to the bathroom and tried to open the door, but found it to be locked. He then started screaming for help, put on his prosthetic legs, and unsuccessfully tried to kick open the door. He then grabbed a cricket bat, which he used to bash out a piece from the door, and, having done so and seeing the key lying on the toilet floor, he unlocked the door and found Riva slumped with her weight on the toilet bowl. She was not breathing. He held her and at some point thought he heard her breathing. And so he pulled her into the bathroom before telephoning another resident of the estate, Mr. Stander. The phone call was made at 3:19 a.m., followed by the emergency number of Netcare 911, a paramedical organisation, at 3:20, and then the estate security some 90 seconds later. He thereafter carried Riva down the stairs, where he was found first by Mr. Stander and shortly thereafter by Dr. Stipp when they arrived at the house. With ample justification, the court found the accused to have been a very poor witness. His version varied substantially. At the outset, he stated that he had fired the shots before I knew it, and at a time when he was not sure if there was somebody in the toilet. This soon changed to a version that he had fired as he believed that whoever was in the toilet was going to come out to attack him. He later changed this to say that he had never intended to shoot at all, that he had not fired at the door on purpose, and that he had not wanted to shoot at any intruder coming out of the toilet. In the light of these contradictions, one really does not know what his explanation is for having fired the fatal shots, an issue to which I shall revert in due course. There were other inherent improbabilities in his version, some of which were mentioned by the trial court in its judgment. But it is not necessary to examine the accused's credibility in any greater detail for the purposes of this judgment, as despite these deficiencies, the trial court concluded that it had not been shown that the state's version, that there had been an argument between the accused and the deceased, which had led to her fleeing to lock herself into the toilet and them shooting her through the door, was true beyond a reasonable doubt, and that the state had not shown that the accused had fired at the toilet door for any reason other than he had thought there was an intruder behind it. It therefore concluded that it could not be said that the accused did not entertain a genuine belief that there was an intruder in the toilet who posed a threat to him, and therefore, I quote, he cannot be found guilty of murder dolus directus, unquote. Although it is not clear from the judgment, this finding appears to have been based on the reasoning that the accused could not be found guilty of murder with direct intent, as he had not known that Riva was in the toilet. The correctness of this latter conclusion was not an issue raised in this appeal. Importantly, the trial court went on to find that the accused, in shooting as he did, had not done so with so-called legal intent or dolus eventualis, an issue that lies at the heart of this appeal. However, it found that the shooting had been unlawful, and that although the accused had not had the necessary intention to kill the deceased, he had done so negligently and was therefore guilty of culpable homicide. The accused was thereupon sentenced to 5 years imprisonment, capable of being converted to correctional supervision under Section 276(1)(I) of the CPEA. It was pursuant to this finding that the state sought and obtained the trial court's leave to appeal to this court in respect of questions of law reserved under Section 319 of the CPA. The questions so reserved were the following, I quote, 1. Whether the principles of dolus eventualis were correctly applied to the accepted facts and the conduct of the accused, including error in objecto. 2. Whether the court correctly conceived and applied the legal principles pertaining to circumstantial evidence and or pertaining to multiple defences by an accused. 3. Whether the court was correct in its construction and reliance on an alternative version of the accused, and that this alternative version was reasonably possibly true. It is probably wise at this stage to briefly explain the ambit of this appeal and what this court may consider. As a general rule, an appeal is a complete rehearing without the leading of evidence, in which a trial court's conclusions of both fact and law may be challenged by having regard to the evidence on record. As a general rule, then, a person convicted of a crime may on appeal challenge the credibility of the witnesses who testified at the trial, as well as the factual findings made by the trial court upon which the conviction was based. The trial court's conclusions on matters of law relevant to the conviction may also be disputed. However, in a case such as this, where effectively the state seeks to appeal against the acquittal of the accused, in this instance on the charge of murder, and the appeal is brought under the provisions of Section 319, different considerations apply. Of course, the state may well feel justifiably aggrieved by a trial court acquitting an accused person when on the facts of the case a conviction should have followed. But in such a case, as was observed by Corbett CJ in Mahmoud, I quote, "The traditional policy and practice of our law is that an acquittal by a competent court in a criminal case is final and conclusive and may not be questioned in any subsequent proceedings. Consequently, as opposed to an accused who has the benefit of appealing against a conviction based on an alleged incorrect factual finding, the state may not appeal against an acquittal based solely on findings of fact. And as Chaskelson CJ pointed out in Besson, prior to 1948, the state could also not appeal against a finding of law made in a trial before a judge, which resulted in the acquittal of an accused person. In 1948, the Criminal Procedure Act, then in force, was amended to make provision for the reservation of questions of law at the instance of the state in terms substantially similar to Section 319 of the present Act. In the light of these decisions, unless there is statutory authority, the state has no right to appeal, save where there's a right bestowed upon it to do so. In this instance, its right is limited to the 3 questions of law reserved, quoted above. This court cannot interfere, for example, with the factual decision made by the trial court rejecting the state's version that there had been a disagreement between the appellant and the deceased that had led the deceased to hide herself in the toilet to escape from him before being shot. This matter must therefore proceed as was accepted by the state, on the basis both that its rejected version cannot be reconsidered and that it has not been shown that the accused had acted with the direct intention to kill the deceased. The state's case before this court therefore revolved primarily on whether the trial court had erred in regard to the issue of dolus eventualis. It is necessary to explain certain of the issues that arise for consideration in a murder case. Over the years, jurists have developed what has been referred to as a grammar of criminal liability. As already mentioned, murder is the unlawful and intentional killing of another person. In order to prove the guilt of an accused on a charge of murder, the state must therefore establish that the perpetrator committed the act that led to the death of the deceased with the necessary intention to kill, which is known in our law as dolus. Negligence or culpa on the part of the perpetrator is insufficient. In cases of murder, there are principally 2 forms of dolus which arise: dolus directus and dolus eventualis. These terms are nothing more than labels that are used by lawyers to connote a particular form of intention on the part of a person who commits a criminal act. In the case of murder, a person acts with dolus directus if he or she committed the offence with the specific object and purpose of killing the deceased. Dolus eventualis, on the other hand, although a relatively straightforward concept, is somewhat different. In contrast to dolus directus, in a case of murder, where the object and purpose of the perpetrator is specifically to cause death, a person's intention in the form of dolus eventualis arises if the perpetrator foresees the risk of death occurring, but nevertheless continues to act, appreciating that death might well occur, and therefore gambling, as it were, with the life of the person against whom the act is directed. It therefore consists of 2 parts. 1, foresight of the possibility of death occurring, and 2, reconciliation with that foreseen possibility. This second element has been expressed in various ways. For example, it has been said that the person must act reckless as to the consequences, a phrase that has caused some confusion, as some have interpreted to mean gross negligence. or the person must have been reconciled with a foreseeable outcome. Terminology aside, it is necessary to stress that the wrongdoer does not have to foresee death as a probable consequence of his or her actions. It is sufficient that the possibility of death is foreseen, which, coupled with a disregard of that consequence, is sufficient to constitute the necessary criminal intent. These are the basic principles to be borne in mind in considering the first of the three legal questions reserved for decision in this appeal. The first relates specifically to whether the trial court properly applied these principles to the facts that it had found had been proved. In considering whether it did, it is necessary to quote fairly fully the trial court's reasoning relevant to whether the accused had acted with dolus eventualis when he fired the fatal shots through the door of the toilet cubicle. In this regard, it said the following, I quote, "I now deal with dolus eventualis or legal intent. The question is, 1. Did the accused subjectively foresee that it could be the deceased behind the toilet door? And 2. Notwithstanding the foresight, did he then fire the shots, thereby reconciling himself to the possibility that it could be the deceased in the toilet? The evidence before this court does not support the state's contention that this could be a case of dolus eventualis. On the contrary, the evidence shows that from the onset the accused believed that at the time he fired shots into the toilet door, the deceased was in the bedroom while the intruders were in the toilet. This belief was communicated to a number of people shortly after the incident. After recording, that's the end of the first quote from the judgment. After recording that the accused had told the persons who first arrived on the scene, including Dr. Stipp and the police, that he had shot the deceased believing that she was an intruder, the court continued, and I quote again, "Counsel for the defence correctly argued that it was highly improbable that the accused would have made this up so quickly and be consistent in his version, even at the bail application, before he had access to the police docket and before he was privy to the evidence on behalf of the state at the bail application. The question is, did the accused foresee the possibility of the resultant death, yet persisted in his deed reckless whether death ensued or not? In the circumstances of this case, the answer has to be no. Although during argument, counsel for the state referred to a good grouping of bullets fired at the door as proof that there was intention to kill the person behind the door, there was nothing in the evidence to support this. How could the accused reasonably have foreseen that the shots he fired would kill the deceased or whoever was behind the door? Clearly, he did not subjectively foresee this as a possibility, that he would kill the person behind the door, let alone the deceased, as he thought she was in the bedroom at the time. The version of the accused was that, had he intended to kill the person behind the door, he would have aimed higher at chest level. This was not contradicted. To find an intention to kill the deceased in particular would be tantamount to saying inter alia that the accused's reaction after he realized that he had shot the deceased was faked, that he was play-acting merely to delude the onlookers at the time. Dr. Stipp, an independent witness who was at the accused's house minutes after the incident had occurred, stated that the accused looked genuinely distraught as he prayed to God and as he pleaded with him to help save the deceased. There was nothing to gainsay that observation, and this court has not been given any reason to reject it, and we accept it as true and reliable. This court also accepts that there was no intention to kill the person behind the door. It follows that the accused's erroneous belief that his life was in danger excludes dolus. The accused, therefore, cannot be found guilty of dolus eventualis. That is the end of the quote from the judgment of the trial court. I find the reasoning in this passage to be confusing in various respects. The rhetorical question, how could the accused reasonably have foreseen that the shots he fired would kill the deceased or whoever was behind the door, wrongly applies an objective rather than a subjective approach to the question of dolus. The issue was not what was reasonably foreseeable when the accused fired at the toilet door, but whether he actually foresaw that death might occur when he did so. As Holmes J.A. emphasized in Squala, the distinction must be observed between what actually went on in the mind of the accused and what would have gone on in the mind of a reasonable person, in the position of the accused. In other words, the distinction between subjective foresight and objective foreseeability must not become blurred. Moreover, the question indicates that the court found the presence of a person behind the door not to have been reasonably foreseeable. But this is at odds with its subsequent conclusion that the accused was guilty of culpable homicide on the basis that a reasonable person in the same circumstances would have foreseen the reasonable possibility that the shots fired at the door of the toilet might kill whoever was in the toilet. Furthermore, the finding that the accused had not subjectively foreseen that he would kill whoever was behind the door, and that if he had intended to do so, he would have aimed higher than he did, conflates the test of what is required to establish dolus directus with the assessment of dolus eventualis. The issue was not whether the accused had as his direct objective the death of the person behind the door. What was required in considering the presence or otherwise of dolus eventualis was whether he had foreseen the possible death of the person behind the door and reconciled himself with that event. The conclusion of the trial court that the accused had not foreseen the possibility of death occurring, as he had not had the direct intent to kill, shows that an incorrect test was applied. There was a further fundamental error. It is apparent from the extract of the judgment quoted above, in particular the two questions posed at the outset and the passages that I have emphasized, that the trial court's consideration of dolus eventualis centered upon whether the accused knew that the person in the toilet cubicle was Riva, and its conclusion that dolus eventualis had not been proved was premised upon an acceptance that, as he had thought Riva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that as the accused did not realize it was Riva in the toilet, he did not foresee that his action in shooting could cause her death, and he could not be held guilty of her murder. This finding goes to the heart of the first question of law reserved, whether the principles of dolus eventualis, including so-called error and objecto, were properly applied. In this regard, it is necessary to stress that although a perpetrator's intention to kill must relate to the person killed, this does not mean that a perpetrator must know or appreciate the identity of his victim. A person who causes a bomb to explode in a crowded place will probably be ignorant of the identity of his or her victims, but will nevertheless have the intention to kill those who might die in the resultant explosion. Reverting to the lexicon of a lawyer, this is known as intent in the form of so-called dolus indeterminatus, that is, the killing of an indeterminate person. It is not a form of intention apart from dolus directus or dolus eventualis. It is merely a label meaning that the perpetrator's intention is directed at a person or persons of unknown identity. A perpetrator can therefore act with dolus indeterminatus simultaneously with dolus eventualis. For example, as Snowman points out, and as this court has recently observed, our courts have consistently held persons engaged in a wild shootout in the course of an armed robbery to be liable for murder on the basis of their having acted with both dolus eventualis and dolus indeterminatus, where persons were killed as a result. What was in issue, therefore, was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. The accused's incorrect appreciation as to who was in the cubicle, on his version, is not determinative of whether he had the requisite criminal intent. Consequently, by confining its assessment of dolus eventualis to whether the accused had foreseen that it was Riva behind the door, the trial court misdirected itself as to the appropriate legal issue. This conclusion shows the fallacy in the submission of counsel for the accused that the first question of law raised solely a question of fact. Since the question as to the form of the intention of an accused in a case of murder invokes a factual inquiry, at best for the accused, the first question reserved invokes an issue of both mixed fact and law. And as there was an incorrect application of the legal issue, the first point of law reserve must be determined in favour of the state. A further issue which arises in respect of dolus eventualis overlaps with the second point of law reserve for decision, namely whether the legal principles relating to circumstantial evidence were correctly applied. As this court has pointed out, while the subjective state of mind of an accused person in a case such as this is an issue of fact that can often only be inferred from the circumstances surrounding the infliction of the fatal injury, the inference is to be properly drawn, must be consistent with all the proved facts. It is thus trite that a trial court must consider that the totality of the evidence led to determine whether the essential elements of a crime have been proved. As Nugent J. stated in Van der Meyden, a passage oft-cited with approval in this court, I quote, "The proper test is that an accused is bound to be convicted if the evidence establishes his guilt beyond reasonable doubt. And the logical corollary is that he must be acquitted if it is reasonably possible that he might be innocent. The process of reasoning which is appropriate to the application of that test in any particular case will depend on the nature of the evidence which the court has before it. What must be borne in mind, however, is that the conclusion which is reached, whether it be to convict or to acquit, must account for all the evidence. Some of the evidence might be found to be false, some of it might be found to be unreliable, and some of it might be found to be only possibly false or unreliable, but none of it may simply be ignored. In Mahmoud, one of the parties had been an accused in previous criminal proceedings during which he had made certain vital admissions relevant to the issues in the subsequent proceedings. An application to use the evidence in the previous proceedings was ruled inadmissible, and the issue arose whether this ruling was an issue of fact or of law. Corbett CJ in this court held that the trial court, which had ruled the evidence to be inadmissible, had erred as a matter of law, and that it would have served the due administration of justice for the evidence to have been admitted. There seems to me to be no difference in principle between the exclusion of relevant evidence by ruling it inadmissible and excluding such evidence once admitted by not taking it into account to decide the issues in dispute. In either event, the judicial process becomes flawed by regard not being had to material which might affect the outcome. As much as excluding evidence on the basis of admissibility is a legal issue, it seems to me to also be a legal issue should account not be taken of any evidence placed before court which ought to be weighed in the scales. Illustrative of this is the decision of the Canadian Supreme Court in R versus B, to which counsel for both sides referred us. The accused in that case had been charged with assault, an allegation they denied. The trial judge acquitted them, but the Court of Appeal allowed the Crown's appeal and ordered a new trial. In doing so, it acknowledged that under the Canadian Criminal Code, similar to the position in this country, it was not open to an appellate court to consider the reasonableness of a trial judge's findings of fact, but stated it could determine whether the trial court had properly directed itself to all the relevant evidence bearing on the relevant issues. It held that the trial judge had ignored certain evidence or failed to mention it, and, in so doing, displayed a lack of appreciation of the relevant evidence which could have had a bearing on the result. This justified an appeal court interfering with the decision. In a further appeal, this time by the accused, the Supreme Court of Canada confirmed the order of the Court of Appeal. In doing so, Wilson J. stated that although it had not been open for the Court of Appeal to overturn the acquittal if it found it to be unreasonable or unsupported by the evidence, it could do so on questions of law, and that an appeal would lie where the question of law originates from the trial judge's conclusion that he or she is not convinced of the guilt of the accused because of an erroneous approach to or treatment of the evidence adduced at trial. After referring to the judgment of the majority of the Canadian Supreme Court in Harper, in which the court had held that where the record, including the reasons for judgment, discloses a lack of appreciation of relevant evidence, and more particularly the complete disregard of such evidence, a Court of Appeal could intervene, Wilson J. cited with approval the following comment of Marshall J. in a judgment of the Newfoundland Court of Appeal in R versus Roman, a case also involving an acquittal, a passage which counsel for the accused conceded in this court would also amount to an accurate reflection of our law. And I quote the passage. There is a distinction between reassessment by a trial court of evidence for the purpose of weighing its credibility to determine culpability on the one hand, and on the other, reviewing the record to ascertain if there has been an absence of appreciation of relevant evidence. The former requires addressing questions of fact and is placed outside the purview of an appellate tribunal. The latter inquiry is one of law, because if the proceedings indicate a lack of appreciation of relevant evidence, it becomes a reviewable question of law as to whether this lack precluded the trial judge from effectively interpreting and applying the law. In the present case, although the question of the accused's intention at the relevant time is one of fact to be determined by inference, there regrettably does not appear to have been such an absence of appreciation of material evidence. There does appear to have been such an absence of appreciation of material evidence relevant to that issue. In this regard, the failure of the court to take into account the evidence of Captain Mangena, a police forensic expert whose evidence as to the reconstruction of the crime scene was found by the court to have been particularly useful, is of particular importance. Having regard to the position of the bullet holes in the door, the marks the bullets left in the toilet cubicle, and the position of the injuries on the deceased body, and after making use inter alia of laser technology, he determined that the deceased must have been standing behind the door when she was first shot and then collapsed down towards the toilet bowl. Although the precise dimensions of the toilet cubicle do not appear from the record in this court, it is clear from the photographs that it is extremely small. And it is also apparent from the reconstruction and the photographs demonstrating with laser beams and steel rods the path each bullet had travelled, that all the shots fired through the door would almost inevitably have struck a person behind it. There had effectively been nowhere for the deceased to hide. In addition, Captain Mangwena testified that the black Talon ammunition the accused had used was specifically designed for the purpose of self-defence. It would penetrate a wooden door without disintegrating, but would mushroom on striking a soft, moist target such as human flesh, causing devastating wounds to any person who might be hit. The veracity of this is borne out by the photographs depicting the injuries that the deceased sustained, were correctly described by the trial court as being horrendous. All of this was circumstantial evidence crucial to a decision on whether the accused at the time he fired the fatal 4 shots must have foreseen and therefore did foresee the potentially fatal consequences of his actions. And yet this evidence was seemingly ignored by the trial court in its assessment of the presence of dolus eventualis. Had it been taken into account, the decision in regard to the absence of dolus eventualis may very well have been different. In the light of the authorities I have mentioned, the failure to take it into account must be regarded as an error of law. Consequently, the first 2 questions reserved for decision must be answered in favour of the prosecution to the extent that I have indicated. I thus turn to the third question, namely whether the trial court was correct in its construction and reliance of an alternative version of the accused, and that this alternative version was reasonably possibly true. This question, as posed, is vague. Questions reserved for decision under Section 319 of the CPA should be clearly formulated so that this court can identify with precision the legal issue it is called upon to decide. At best for the state, the question asks no more than whether the accused version accepted by the trial court was reasonably possibly true. This is a factual decision. As already set out, and on the strength of the authorities to which I have referred, a finding of fact falls beyond the scope of what this court may decide under Section 319. In any event, in the light of my findings in regard to the first 2 questions, the third question, even if it can be construed as being a point of law, seems superfluous. To summarise, in regard to the questions of law reserved for decision of this court, 1. The principles of dolus eventualis, including error in objecto, were incorrectly applied to the facts found to be proved relevant to the conduct of the accused. And 2, the trial court did not correctly conceive and apply the legal principles pertaining to circumstantial evidence. The question then becomes, what should this court do in the light of these findings? The powers of a court in the case of an appeal on a question of law reserved are set out in Section 322 of the CPA as follows. 1. In the case of an appeal against a conviction or of any question of law reserved, the Court of Appeal may A. allow the appeal if it thinks that the judgment of the trial court should be set aside on the ground of a wrong decision of any question of law, or that on any ground there was a failure of justice, or B. give such judgment as ought to have been given at the trial, or impose such punishment as ought to have been imposed at the trial, or C. make such other order as justice may require, provided that, notwithstanding that the Court of Appeal is of opinion that any point raised might be decided in favour of the accused, no conviction or sentence shall be set aside or altered by reason of any irregularity or defect in the record of proceedings unless it appears from the Court of Appeal that a failure of justice has in fact resulted from such irregularity or defect. And in subsection 4, where a question of law has been reserved on the application of a prosecutor in the case of an acquittal, and the Court of Appeal has given a decision in favour of the prosecutor, the Court of Appeal may order that such of the steps referred to in Section 324 be taken as the Court may direct. Under Section 324, so referred to in Section 322(4), where there has been a misdirection of law, as has occurred in this case, proceedings in respect to the same offence may again be instituted before another judge and assessors. Accordingly, it is a permissible option for this Court to set aside the conviction of culpable homicide on count 1 and to order that the accused be tried de novo on that count. However, given the protracted nature of the trial, the time that has already elapsed and the unfairness that may result to either side if witnesses have once again to testify, it would seem to me to be wholly impractical and not in the public interest to allow that course. Indeed, neither side pressed for such an order. Counsel for the accused drew our attention to the fact that the accused has already served the period of direct imprisonment envisaged by the period of correctional supervision imposed upon him by the trial court, and argued that apart from answering the questions of law, this court should exercise its discretion under Section 322 to make no further order. However, in my view, that too is undesirable. The interests of justice require that persons should be convicted of the actual crimes they have committed, and not of lesser offences. That is particularly so in crimes of violence. It would be wrong to effectively think away the fact that an accused person is guilty of murder if he ought to have been convicted of that offence. In my view, the option which most readily presents itself as being in the interest of justice is to consider whether, on the facts found proved, the trial court erred in drawing the inference it did as to dolus eventualis. This is so as in an appeal of this nature, this court is in as good a position as the trial court in drawing inferences of facts from proven facts. In my view, then, the interests of justice require this court, on an acceptance of the facts found proved, if of the view that the incorrect conclusion was reached in respect of dolus, to set aside the conviction of culpable homicide on count 1. The pertinent issue then becomes whether, on the primary facts proved, considering all of the evidence relevant to the issue and applying the correct legal test, the inference has to be drawn that the accused acted with dolus eventualis when he fired the fatal shots. In this regard, the following observation of Bront J.A. and Humphreys is to the point. I quote, "Like any other fact, subjective foresight can be proved by inference. Moreover, common sense dictates that the process of inferential reasoning may start out from the premise that, in accordance with common human experience, the possibility of the consequences that ensued would have been obvious to any person of normal intelligence. The next logical step would then be to ask whether, in the light of all the facts and circumstances of this case, there is any reason to think that the appellant would not have shared this foresight, derived from common human experience with other members of the general population." In arguing that the State had failed to show that the accused lacked the necessary subjective intention in respect of both elements of dolus eventualis, counsel for the accused emphasised the accused's physical difficulties, the fact that he had not been wearing his prostheses at the time, and that he had thus been particularly vulnerable to any aggression directed at him by an intruder. He also placed considerable emphasis on the psychiatric evidence that the accused suffers from a general anxiety disorder and would become anxious very easily in a situation of danger. although he also has a fight rather than flight reaction. The argument appears to have been that in the circumstances that prevailed, the accused may well have fired without thinking of the consequences of his actions. In my view, this cannot be accepted. On his own version, when he thought there was an intruder in the toilet, the accused armed himself with a heavy caliber firearm loaded with ammunition specifically designed for self-defense, screamed at the intruder to get out of his house, and proceeded forward to the bathroom in order to confront whoever might be there. He's a person well trained in the use of firearms and was holding his weapon at the ready in order to shoot. He paused at the entrance to the bathroom, and when he became aware that there was a person in the toilet cubicle, he fired 4 shots through the door. And he never offered an acceptable explanation for having done so. As a matter of common sense, at the time the fatal shots were fired, the possibility of the death of the person behind the door was clearly an obvious result. And in firing not 1, but 4 shots, such a result became even more likely. But that is exactly what the accused did. A court blessed with the wisdom of hindsight should always be cautious of determining that because an accused ought to have foreseen a consequence, he or she must have done so. But in the present case, that inference is irresistible. A person is far more likely to foresee the possibility of death occurring where the weapon used is a lethal firearm, as in the present case, than, say, a pellet gun, unlikely to do serious harm. Indeed, in this court, counsel for the accused, while not conceding that the trial court had erred when it concluded that the accused had not subjectively foreseen the possibility of the death of the person in the toilet, was unable to actively support that finding. In the light of the nature of the firearm and the ammunition used, and the extremely limited space into which the fatal shots were fired, his diffidence is understandable. In these circumstances, I have no doubt that in firing the fatal shots, the accused must have foreseen, and therefore did foresee, that whoever was behind the toilet door might die, but reconciled himself to that event occurring and gambled with that person's life. This constituted dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. As a final counter to the state's case, it was argued that although the accused had not acted in private or so-called self-defense, there had in fact been no attack upon him that he had acted to ward off. He had genuinely but erroneously believed that his life was in danger when he fired the fatal shots. As opposed to what is commonly known as self-defense, this is so-called putative private or self-defense. The principles relevant to these two defences were authoritatively dealt with by this court in de Oliveira and were explained by Smallberger J.A. as follows, I quote, "The test for private defence is objective. Would a reasonable man in the position of the accused have acted in the same way? In putative private defence, it is not lawfulness that is an issue, but culpability. If an accused honestly believes his life or property to be in danger, but objectively viewed they are not, the defensive steps he takes cannot constitute private defence. If in these circumstances he kills someone, his conduct is unlawful. His erroneous belief that his life or property was in danger may well, depending upon the precise circumstances, exclude dolus, in which case liability for the person's death based on intention will also be excluded. At worst for him, he can then be convicted of culpable homicide. On appeal, the unlawfulness of the appellant's conduct was not in issue. Accordingly, the only issue was whether the state had proved beyond all reasonable doubt that the appellant subjectively had the necessary intent to commit the crimes of which he was convicted. In other words, that he did not entertain an honest belief that he was entitled to act in private defence. The immediate difficulty that I have with the accused's reliance upon putative private defence is that when he testified, he stated that he had not intended to shoot the person whom he felt was an intruder. This immediately placed himself beyond the ambit of the defence, although, as I've said, his evidence is so contradictory that one does just not know his true explanation for firing the weapon. His counsel argued that it had to be inferred that he must have viewed whoever was in the toilet as a danger. But as was pointed out in de Oliveira, the defence of putative private defence implies rational but mistaken thought. Even if the accused believed there was someone else in the toilet, his expressed fear that such a person was a danger to his life was not the product of any rational thought. The person concerned was behind a door, and although the accused stated that he had heard a noise which he thought might be caused by the door being opened, it did not open. Thus, not only did he not know who was behind the door, he did not know whether that person in fact constituted any threat to him. In these circumstances, although he may have been anxious, it is inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without even taking that most elementary precaution of firing a warning shot, which the accused said he elected not to fire as he thought the ricochet might harm him. This constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully, which was in no way disturbed by his vacillating and untruthful evidence in regard to his state of mind when he fired his weapon. In order to disturb the natural inference that a person intends the probable consequences of his actions, the accused was required to establish at least a factual foundation for his alleged genuine belief of an imminent attack upon him. This the accused did not do. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom. And when there was, he did. In doing so, he must have foreseen, and therefore did foresee, that the person he was firing at behind the door might be fatally injured. Yet he fired without having a rational or genuine fear that his life was in danger. The defence of putative private or self-defence cannot be sustained, and there is no bar to a finding that he acted with dolus eventualis in causing the death of the deceased. In the result, on count 1 in the indictment, the accused ought to have been found guilty of murder on the basis that he had fired the fatal shots with criminal intent in the form of dolus eventualis. As a result of the errors of law referred to, and on a proper appraisal of the facts, he ought to have been convicted not of culpable homicide on that count, but of murder. In the interest of justice, the conviction and the sentence imposed in respect thereof must be set aside and the conviction substituted with a conviction of the correct offence. Of course, the accused has now served a portion of the sentence imposed upon him in respect of the lesser offence of culpable homicide. But the issue of what would be an appropriate sentence was not debated before this court, quite properly, particularly in the light of the Constitutional Court's judgments in Nobolisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account. Before closing, it is necessary to make a final comment. The trial was conducted in the glare of international attention and the focus of television cameras, which must have added to the inherently heavy rigours that are brought to bear upon trial courts in conducting lengthy and complicated trials. The trial judge conducted the hearing with a degree of dignity and patience that is a credit to the judiciary of this country. The fact that this court has determined that certain mistakes were made should not be seen as an adverse comment upon her competence and ability. The fact is that different judges reach different conclusions, and in the light of an appeal structure, those of the appellate court prevail. But the fact that the appeal has succeeded is not to be regarded as a slight upon the trial judge, who is to be congratulated for the manner in which he conducted the proceedings. I conclude with the following order being to be made. 1. The first 2 questions of law reserved are answered in favour of the Director of Public Prosecutions. 2. The accused's conviction and sentence on count 1 are set aside and replaced with the following. Guilty of murder, with the accused having had criminal intent in the form of dolus eventualis. 3. The matter is referred back to the trial court to consider an appropriate sentence afresh in the light of the comments in this judgment. Court will adjourn.
just brushing up on my party. We are going to make it number 12, official. Let me teach you a quick word.
Yeah.
Quite a star. A woman who has mastered the art of dancing in high heels. It's up and flip.
Get a bottle of Glenfiddich 12-year-old with 2 glasses for only $3.99.99 and help make party South Africa's 12th official language. Tops at Spa. Shake things up.
In Africa, technology has created many new ways of doing things.
ICT is an increasingly important part of everybody's life.
It's being used in education, for social media, and now for farming too.
The best thing about internet for a farmer is that we get to share information.
On Network, we give you all the important African technology and social media news. That's Network with Ms. Phumelele Zondi every Sunday at 7:30 p.m. Central African Time, only on SABC News.
This is Newsroom, Jumbo Africa, and a very warm welcome here in Johannesburg, South Africa. I'm Elvis Preston. As you know, the show is live and we broadcast from our studios in Auckland Park to the rest of the African continent. We're also streaming live on YouTube with the entire show available on our YouTube channel. Now, today we're asking you a very important question that relates to the Oscar trial. Should Oscar Pistorius go back to jail today? Now, you heard the question, or you heard the answer as well there from the judge, and we'll get an update from our reporter, Griselda Lewis, who's at courtside, to give us what's happening there. But let's first take our first story now. Court of Appeal in Bloemfontein says that Oscar Pistorius should have been found guilty of murder. South Africa and China have signed 26 agreements valued at 94 billion rand following a meeting between President Jacob Zuma and his Chinese counterpart Xi Jinping in Pretoria yesterday. And the armed couple suspected of killing 14 people in a mass shooting in California in the United States has been killed by the police. Now, those are all your headlines. Now, Kendall Makamate will be back with you a little bit later to give you some headlines and the story and the stories that unfolds on the sport field. But right now, let's go to one of our top stories this morning. And this is the Chinese President Xi Jinping that has kicked off his official state visit in South Africa. The Chinese head of state touched down in South Africa yesterday following a visit to Zimbabwe. President Jacob Zuma and his cabinet will be looking to shift the focus from expropriation of natural resources by China to beneficiation, which will be advantageous to South Africa.
The traditional pomp and ceremony to welcome South Africa's single largest trading partner. President Jacob Zuma welcomes his Chinese counterpart Xi Jinping to the nation's capital. Both countries share a long history of cooperation dating back to China's support for the ANC during the anti-apartheid liberation struggle. President Xi Jinping had brought a high-level delegation of business people and cabinet ministers. President Zuma says South Africa is looking for equitable trade relations with China.
We focused on especially our economic and trade relations. We have just witnessed the signing of 26 agreements that are worth 94 billion rand.
China's president says both nations stand to benefit from strengthened economic relations.
We share the view that the two sides should continue to view and promote China-South Africa relations from strategic and long-term perspectives. We need to maintain close high-level exchanges, strengthen the sharing of governance experience, and also on issues concerning our major concerns, we should extend mutual understanding and support.
President Zuma says there is a need for the international community to work in solidarity to condemn global terror attacks that are attempting to shake various economies. President Zuma visited China in December 2014. At that time, the two leaders concluded the 5 to 10-year strategic program for cooperation between South Africa and the People's Republic of China. Both nations will also look at increasing marine cooperation, infrastructure development, and human resources cooperation.
Our top story this hour. Oscar Pistorius' culpable homicide conviction has been overturned just now to murder in the Supreme Court of Appeal in Bloemfontein. Justice Eric Leach has just finished reading that judgment in the case between the state and Pistorius. Now, he poked holes in the High Court Judge Thokozile Masipa's verdict and found that the trial incorrectly applied the principle of dolus eventualis, which deals with indirect intention to kill. Justice Leach also said that Judge Masipa didn't take into account relevant circumstantial evidence, but he congratulated her on a fantastic trial. But now let's cross back to the Supreme Court of Appeal in Bloemfontein to our reporter on the ground there, Griselda Lewis. Griselda, a very good morning to you.
Well, a very good afternoon to you, Elvis.
What is the latest that just came out of there? I've just read some of the startling evidence there, or the Pistorius culpable homicide conviction. It has been overturned by Justice Leach. Give us an update.
Well, seriously, what has taken place in this court here this morning is certainly groundbreaking in that the culpable homicide conviction of Oscar Pistorius, as you've heard, has been overturned. He's been found guilty of murder. Certainly what will happen now is that this matter will be referred to the High Court in Pretoria, where there will be sentencing arguments in aggravation of sentence as well, to determine what a sentence Oscar Pistorius should receive. But a serious indictment on the initial finding by Judge Thokozile Masipa, certainly saying that she did not correctly apply the facts to the law, and that she ignored crucial evidence. You'd recall that was one of the main facts that the state had put across, saying that Judge Thokozile Masipa had ignored some of the crucial evidence, including the testimony of ballistics expert Chris Mangena. You would recall during the trial he gave quite a detailed account of where Oscar Pistorius was standing at the time that he fired those shots, saying that Oscar Pistorius did not act rationally. And on the issue of dolus eventualis, which was really clarified in this instance, whether Oscar Pistorius could have foreseen that he would shoot and kill someone, Justice Leach essentially said that it was not the issue of whether somebody, whether Reeva Steenkamp was behind that door, but Oscar Pistorius should have foreseen that when he fired those 4 shots through the bathroom door, he would have known that he would have killed someone. The issue was not whether it was Reeva Steenkamp. So certainly the issue of dolus eventualis, the clarification thereof, a serious indictment again on Judge Thokozile Masipa, that she incorrectly applied the principle of dolus eventualis. So essentially Oscar Pistorius, knowing that when he fired those 4 shots through the door, he would have killed someone. The crucial evidence also that was ignored, according to Justice Leach, says that cannot be ignored. The fact that some of the crucial evidence in this case was not taken into account is a serious indictment on the way that the trial court had conducted those proceedings. I'm going to chat a little bit more now to our criminal law expert here, Estienne Ferreira, who's been with us throughout the morning. Estienne, a serious indictment on the verdict that was handed down by the High Court in Pretoria.
Exactly that's what you're saying. What happened here today is, irrespective of what the sentence is going to be now, it's just saying that she didn't follow the law principle at all. She took a route. If we want to say that she didn't do her job, it's not fair to say that. She took the direct route through the middle, saying, listen, I'm going to give him a sentence. If I don't send him to jail, people's going to be unhappy. If I send him to jail, other people's going to be unhappy. So take the route down the middle, send him to jail, let him sit a few months, and let him come out. Her job is done.
One of the crucial aspects as well, what Justice Leach said, that they couldn't ignore that Oscar Pistorius had changed his version several times. You know, quite scathing, Justice Leach saying, you cannot even say at this point exactly what Oscar Pistorius' version was. Quite an indictment on that part as well, that Judge Thokozile Masipa seemed to have chosen a version for Oscar Pistorius.
I won't go so far as to say she's chosen a verdict for him, a version for him. he contradicted himself throughout his statements, and that is why Justice Leach also said that he was not a credible witness. And what Judge Masipa then chose to believe is a version that she thought was the right version from all the versions she gathered from him, and that's the version that she took.
On the aspect as well of the ballistics expert Chris Mangena, when he described where Oscar Pistorius was standing, what position he was standing in, the fact that a crucial evidence, that crucial testimony had been ignored.
That's inexcusable. I mean, if you look at the entry level of the shots that he fired, it wasn't directed to scare somebody. It wasn't directed on the floor or to the ceiling. It was in the middle of the door. So to ignore a fact like that is such a crucial part of the evidence is inexcusable.
With regard to what happens next, obviously we've heard inside court that the matter will be referred to the High Court again. Sentencing arguments will certainly get underway. What are the possibilities here? Take a toss.
Well, in my opinion, he'll stay on parole. He won't be incarcerated as of yet. He'll wait for his sentence. But if we look at the possible sentence for him now, I'd go for a minimum of 15 years.
Also described as a tragedy of Shakespearean proportions. The media interest and all of that is one of the issues that Justice Leach had alluded to. But in terms of the law going forward, the clarification on the issue of dolus eventualis, it's quite clear now that Judge Thokozile Masipa did not interpret the law correctly. The principle of dolus eventualis was not applied correctly as well. Speaking to that aspect and the fact that Oscar Pistorius, according to this court, foresaw that he would shoot and kill someone behind the door. Just a clarification on that.
Well, firstly, it was an excellent judgment by Justice Leach. He read that there can be no discrepancies about what is dolus eventualis now. He gave a clear indication of what it is. Oscar Pistorius knew exactly what he was doing, what he was shooting. Like he said, there is no reason. You cannot say he didn't want to shoot Riva behind the door. That doesn't matter.
Quite interestingly, the analogy also with the bomber does not need to know the identity of
the people that he's going to kill. Yeah. He doesn't have to know the identity of the person behind the door. He must just foresee that there is somebody behind the door and the possibility of him shooting through the door, that he would injure or kill a person behind that door.
Right, thank you very much for always there for your insight. Let's get some more reaction here as well from the ANC Women's League, who've been with this case since the very beginning. Mama, thank you very much for your time this morning. Certainly, your reaction to today's judgment?
We are so happy as the Women's League, overwhelmed, excited, and we are satisfied with the outcome of the court today, that the culpable homicide now will be changed to murder. And I think that's what also the family of Riva Steenkamp was expecting. And we stood by the family, and we also want to thank the women of South Africa, ordinary women out there who were with us all the time, to make sure that we really make the noise that Oscar Pistorius failed to hear on the day when he shot Riva. Now, we made that noise as the Women's League, and we will continue making it up until the last day when he is sentenced. And we also want to say the abuse of women and children will not be accepted, because in this instance, this was an abuse. When you check on the track record on the relationship of Riva Steenkamp and Pistorius, you can see that the poor girl was being abused continuously, and it ended up taking his life. And we are saying today, no to abuse of women, and we are saying let the killing of women be stopped. And we also want to say to the justice system, this should be a learning curve for our magistrate, our judges, that they shouldn't take sides. They must consider the merits of the case and correct.
Are you saying that Judge Thokozile Masipa took sides?
No, she took sides. She took the side of Oscar Pistorius, and we don't know why. And that has been always the complaint that we put forward, to say we have a problem on how the issue of this case was being dealt with and the finality of it. And today, justice has been served.
Just fast forward, what would you think is the appropriate sentence in this regard?
The appropriate sentence in this instance, it should be 20 years or life sentence. Because the life of Riva Steenkamp was a precious life. She had a career which was at the peak, which Oscar Pistorius cut it very shortly for her, which the family was also expecting to see something out of her career. So we are saying he should receive a very harsh sentence.
Thank you very much for your time. There's certainly reaction from the ANC Women's League, but what we do know at this stage is that the National Prosecuting Authority will not ask that Oscar Pistorius be incarcerated at this point. We will have to wait, of course, for that sentencing. You'd know that Pistorius has been under a house arrest at his uncle's Waterkloof home. Let's get some more reaction here also as well from Mr. Africa, who's been outside this court, Tukelo Africa, who's been outside this court since we came to Bloemfontein. Let me get your reaction, first of all, sir, with regard to the findings in this court.
Griselda, I'm very much disappointed in this regard because we were hoping that Justice Leach will definitely give Oscar a break. Since we've been talking about the same issue of hands off Oscar Pistorius, but now it doesn't go according to our wishes. It goes according to the justice system of South Africa, and we respect that. For the fact that Oscar is a human being, we definitely think that it's very much unfair on him for the matter to be resentencing. So it's definitely hurting. I think wherever he is, his emotions are very much higher right now. He feels that he can even not watch the news and all that. It's very much painful, especially if you know the jail. If you don't know the jail, then you can sing like a bird, wishing whoever to go to jail.
But if you do the crime, you've got to do the time.
Hence, we are saying that we respect the justice system of South Africa in terms of the decision that Judge Leach have just right now. We are not saying whoever that is doing criminal activities must never go to jail. What we are saying is people must be given a second chance, really, because now if you can just check, from the trial itself, I think many people think that.
But I guess many would argue also that if you give Oscar Pistorius a second chance, of course, following the findings of this court, everybody else deserves a chance. Anybody else who is found guilty of murder deserves a chance.
Hence, Oscar Pistorius said, Griselda, that he was never intending to kill anybody else.
But this court found otherwise.
Yes, that is how the justice system it is. There is nothing that we can contest about, even if we can launch our own opinions and so forth. But it's a tough luck that we can't just change everything.
Well, we certainly do rely on the findings of every single court. Thank you very much for your time there. Tukelo Africa has been outside this court showing support for Oscar Pistorius. Not much reaction from Riva Steenkamp's mother. When I did speak to her a bit early on before the proceedings got underway this morning, all she could say was God knows, and a sigh of relief, I must say, but also very difficult probably for the Steenkamp family in that finally this, for them, they believe that the overturning of the culpable homicide conviction to murder is something that they wanted. They wanted a harsher sentence, a conviction for Oscar Pistorius. Certainly that is what has happened in this case. Many now saying that they're relying on what the High Court will find and what sentence Oscar Pistorius will receive. But that's about the reaction that we're getting outside of this court at the moment. We'll certainly want to hear from the National Prosecuting Authority. There's not a representative from the NPA here today, but there might be quite a sense of relief on the part of the National Prosecuting Authority, because they consistently argued that they felt that the sentence itself was lenient and that Oscar Pistorius should have from the very onset been found guilty of murder. They've been clearly stating that Oscar Pistorius could foresee what he was doing when he fired those 4 shots through that bathroom door, and certainly that's what the Supreme Court of Appeal has ruled today, that Oscar Pistorius, irrespective of who was behind that door, could have foreseen that he would have shot and killed someone.
Thank you, Griselda. That's Griselda Lewis live from Bloemfontein, and we ask you the question, should Oscar Pistorius go back to jail? But the question has been answered really by the judge in terms of taking that sentence and converting that to murder. So what do you make of that sentence? That is our new question to you. What do you make of the verdict imposed on Oscar Pistorius? But we have to take a break right now, and we'll be back right at the top of the hour.
SABC News. We report, contextualize and present news and current affairs honestly, fairly and fully. We consider it a duty to provide consistent, relevant, useful and top-quality information and analysis. Our mission is to provide credible, accurate and interesting news programming, bringing news into everyone's homes in everyone's languages. Thank you, South Africa, for relying on SABC News for quality news output and for making us your #1 source of information. SABC News, Africa's news leader.
This is Newsroom, Jumbo Africa, and a very warm welcome to the final hour right here in Johannesburg, South Africa. I'm Elvis Preslin, and this show is live and be broadcast from our studios in Auckland Park, Johannesburg, to the rest of the African continent. We're also streaming live on YouTube with the entire show available on our YouTube channel. Now today we ask you a very important question. How do you view, or what is your take on the murder verdict imposed on Oscar Pistorius that we've just seen? That's our question to you. What do you make of the murder verdict imposed on Oscar Pistorius? Let us know what's on your mind on the Facebook page as well as on the Twitter page. But first, let's take a look at all your headlines. The Appeal Court of Appeal in Bloemfontein says that Oscar Pistorius should have been found guilty of murder, which he was. South Africa and China have signed 26 agreements valued at 94 billion rand following a meeting between President Jacob Zuma and his Chinese counterpart Xi Jinping in Pretoria yesterday. And breaking news, Springbok coach Heineke Meyer has resigned. Kendall will tell you more about that when he comes up a little bit later. Very good morning to you.
Good morning, Elvis. That is certainly breaking news that Heineke Meyer, the current Springbok coach, has decided not to ask for his contract to be renewed. He's resigned from his post and is not going to be taking the Springboks on into the new year if the SARU's General Council agrees with his resignation. They're set to meet on the 11th of December to discuss his future, but he's preempted all of that and said he is resigning. Now, with that said, we'll be covering more about that a little later in the sports bulletin. But in the meantime, we also have other sports news that's been doing the rounds. In fact, we already know that the Proteas will be basically lost their series, and they've got nothing to lose in Delhi. And right now, we've got live visuals that we're looking at right now, and they're out in Delhi playing their last test, and just playing for pride.
It just drifted a little bit in the air.
And the HSBC 7th Series Open is almost upon us as the Blitzbokker put the finishing touches in the title defense. This, of course, is Algeria too strong for Mali, beating them last night in the Under-23 AFCON. 2-0 was the scoreline.
Who was loitering with intent at the bump.
And of course, we'll come back to you with everything else that we've got to say about the Springbok coach Heineke Meyer leaving his job and saying he doesn't want to be re-elected, well, renewed, his contract renewed later on. Then back to you, Elvis.
Thank you, Kendall. Let's now take it from the top. Our top story this hour. You heard it first right here on Channel 404 Newsroom. Oscar Pistorius' culpable homicide conviction has been overturned to murder in the Supreme Court of Appeal in Bloemfontein. Justice Eric Leach has just finished reading that judgment in the case between the state and Pistorius. Now, he poked holes in the High Court Judge Thokozile Masipa's verdict and found that the trial incorrectly applied the principle of dolus eventualis, which deals with the indirect intention to kill. Justice Leach also said that Judge Masipa didn't take into account relevant circumstantial evidence. Leach has further highlighted that one does not have to foresee identity of a person to kill and has given an example related to a bomb being set off. The state wants the court to overturn Pistorius' culpable homicide, which it did, to a more serious murder case, which then carried the minimum sentence, rather, of 15 years in prison. Now let's take a look at the verdict delivered by Justice Eric Leach.
It is inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without even taking that most elementary precaution of firing a warning shot, which the accused said he elected not to fire as he thought the ricochet might harm him. This constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully, which was in no way disturbed by his vacillating and untruthful evidence in regard to his state of mind when he fired his weapon. In order to disturb the natural inference that a person intends the probable consequences of his actions, the accused was required to establish at least a factual foundation for his alleged genuine belief of an imminent attack upon him. This the accused did not do. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom. And when there was, he did. In doing so, he must have foreseen, and therefore did foresee, that the person he was firing at behind the door might be fatally injured. Yet he fired without having a rational or genuine fear that his life was in danger. The defence of putative private or self-defence cannot be sustained, and there is no bar to a finding that he acted with dolus eventualis in courting the death of the deceased. In the result, on count 1 in the indictment, the accused ought to have been found guilty of murder on the basis that he had fired the fatal shots with criminal intent in the form of dolus eventualis. As a result of the errors of law referred to, and on a proper appraisal of the facts, he ought to have been convicted not of culpable homicide on that count, but of murder. In the interest of justice, the conviction and the sentence imposed in respect thereof must be set aside and the conviction substituted with a conviction of the correct offence. Of course, the accused has now served a portion of the sentence imposed upon him in respect of the lesser offence of culpable homicide. But the issue of what would be an appropriate sentence was not debated before this court, quite properly, particularly in the light of the Constitutional Court's judgments in Nobolisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account.
Now, reporter Griselda Lewis spoke to the ANC Women's League leaders outside the Supreme Court of Appeal in Bloemfontein earlier, and they said they are happy about the outcome.
We are so happy as the Women's League, overwhelmed, excited, and we are satisfied with the outcome of the court today, that the culpable homicide now will be changed to murder. And I think that's what also the family of River Steenkamp was expecting. And we stood by the family, and we also want to thank the women of South Africa, ordinary women out there, who were with us all the time, to make sure that we really make the noise that Oscar Pistorius failed to hear on the day when he shot River. Now, we made that noise as the Women's League, and we will continue making it up until the last day when he is sentenced. And we also want to say the abuse of women and children will not be accepted, because in this instance, this was an abuse. When you check on the track record, on the relationship of River Steenkamp and Pistorius, you can see that the poor girl was being abused continuously, and it ended up taking his life. And we are saying today no to abuse of women, and we are saying let the killing of women be stopped. And we also want to say to the justice system, this should be a learning curve for our magistrate, our judges, that they shouldn't take sides. They must consider the merits of the case and correct.
Are you saying that Judge Thokozile Masipa took sides?
No, she took sides. She took the side of Oscar Pistorius, and we don't know why. And that has been always the complaint that we put forward to say we have a problem on how the issue of this case was being dealt with and the finality of it. And today, justice has been served.
Just fast forward, what would you think is the appropriate sentence in this regard?
The appropriate sentence in this instance, it should be 20 years or life sentence. Because the life of Riva Steenkamp was a precious life. She had a career which was at the peak, which Oscar Pistorius cut it very shortly for her, which the family was also expecting to see something out of her career. So we are saying he should receive a very harsh sentence.
Griselda Lewis also spoke to a law expert, Adrian Extian Ferreira.
Irrespectively of what the sentence is going to be now, it's just saying that she didn't follow the law principle at all. She took a route. If we want to say that she didn't do her job, it's not fair to say that. She took the direct route through the middle, saying, listen, I'm going to give him a sentence. If I don't send him to jail, people's going to be unhappy. If I send him to jail, other people's going to be unhappy. So take the route down the middle, send him to jail, let him sit a few months, and let him come out. Her job is done. He contradicted himself throughout his statements, and that is why Justice Leach also said that he was not a credible witness. And what Judge Masipa then chose to believe is a version that she thought was the right version from all the versions she gathered from him, and that's the version that she took. If you look at the entry level of the shots that he fired, it was not directed to scare somebody. It wasn't directed on the floor or to the ceiling. It was in the middle of the door. So to ignore a fact like that is such a crucial part of the evidence is inexcusable. If we look at the possible sentence for him now, I'd go for a minimum of 15 years. Firstly, it was an excellent judgment by Justice Leach. He read out there can be no discrepancies about what is Dulles Eventualis now. He gave a clear indication of what it is. Oscar Pistorius knew exactly what he was doing, what he was shooting. Like he said, there is no reason. You cannot say he didn't want to shoot Riva behind the door. That doesn't matter. He doesn't have to know the identity of the person behind the door. He must just foresee that there is somebody behind the door and the possibility of him shooting through the door, that he would injure or kill the person behind that door.
High Court judgment of the culpable homicide conviction in Oscar Pistorius' case has been set aside by the Supreme Court of Appeal, and that has now changed to murder. Now let's see what you had to say on the social media pages. This one from Gorilla says, Oscar Pistorius, wow, I wonder where is Judge Masipa? Hashtag question mark there from Gorilla. Jay says he was guilty all along, man. Not having this intruder bollocks. Finally, a judge that sees sense. Hashtag Oscar Pistorius, says Jay. Justina says, well done to Gerinel and the team. This case will certainly be remembered for years to come. Hashtag Oscar Pistorius. Chelsea says, but now do you think that Oscar Pistorius will take it to the Constitutional Court? Now that is the question, Chelsea. He's not going to take it lying down or standing up. Andrea from Wake says, well done to the state and NDPP for challenging the High Court finding. That one from Andrea there. These are some of your tweets that we have for you. You can keep them coming and we'll read them as we continue during the course of the show. Let's change track now. As you know, the Chinese President Xi Jinping has kicked off his official state visit to South Africa. The Chinese head of state touched down in South Africa yesterday. That followed the visit to Zimbabwe. President Jacob Zuma and his cabinet will be looking to shift the focus from expropriation of our natural resources here in South Africa by China to beneficiation, which will be advantageous to all of South Africa.
The traditional pomp and ceremony to welcome South Africa's single largest trading partner. President Jacob Zuma welcomes his Chinese counterpart Xi Jinping to the nation's capital. Both countries share a long history of cooperation dating back to China's support for the ANC during the anti-apartheid liberation struggle. President Xi Jinping had brought a high-level delegation of business people and cabinet ministers. President Zuma says South Africa is looking for equitable trade relations with China.
We focused on especially our economic and trade relations. We have just witnessed the signing of 26 agreements that are worth 94 billion rand.
China's president says both nations stand to benefit from strengthened economic relations.
We share the view that the two sides should continue to view and promote China-South Africa relations from strategic and long-term perspectives. We need to maintain close high-level exchanges, strengthen the sharing of governance experience, and also on issues concerning our major concerns, we should extend mutual understanding and support.
President Zuma says there is a need for the international community to work in solidarity to condemn global terror attacks that are attempting to shake various economies. President Zuma visited China in December 2014. At that time, the two leaders concluded the 5 to 10-year strategic program for cooperation between South Africa and the People's Republic of China. Both nations will also look at increasing marine cooperation, infrastructure development, and human resources cooperation.
Further afield now, 14 people have been shot and killed and 17 people wounded in San Bernardino in California in the U.S. Police say 3 gunmen opened fire during a holiday party at a social services agency for the disabled. Police say the suspects were armed with rifles. They are believed to have made their getaway in a dark sport utility vehicle. Later, during a shootout with police, a man and a woman suspected of taking part in the massacre were killed. The motive for the shooting is not yet known. There have been more than 350 shooting incidents in the U.S. this year alone. Back home, the EFF leader Julius Malema is rubbishing Nelson Mandela's legacy and is being driven by a desire to get votes in next year's local government elections. That's the view of Mandela's lawyer and old friend George Bizos and Gauteng Premier David Makhura. The two were reflecting on the state of the nation a few days before the anniversary of Nelson Mandela's death. A few days ago, Mandela told a public gathering in the United Kingdom that Mandela had begun to sell out the revolution by deviating from the Freedom Charter. He went on to say that the former president stayed in a house of rich white men and was looked after by the Oppenheimers.
I'm very concerned that there is a small, ignorant minority who has the cheek to say that Nelson Mandela betrayed the black people in South Africa. This young man and the other small group of people who actually tried to belittle the heritage of Nelson Mandela should be ashamed of themselves.
It can be very easy for somebody who doesn't understand what it really took to bring our country from the precipice of civil war. Probably maybe someone was too young or was just far from the events, forgivable. When armed struggle was suspended, we opposed it. We didn't want, we wanted to continue the war. We opposed the idea that we must settle with the enemy, peaceful negotiations. But through dialogue and conversation, we understood why that was a wise thing.
Now, that's all we have for you for now. Let's take a break, and we'll be right back after that.
South Africa is the third leading country globally in TB infections.
We have 9 million new cases occurring globally, and 30% of those cases are occurring in the African region.
And there are two broad kinds of drug-resistant TB, so to speak. The one is MDR TB, and the other is XDR TB.
To ensure that everyone who's diagnosed with TB is tested for HIV.
There's grossly inadequate funding for TB. Vaccine, drug and diagnostic research. We need a lot more.
Join me on Health Talk every Saturday morning between 9 a.m. and 10 a.m. as we unpack current health stories.
Welcome back. Time for us to take a more regional focus here with our broadcast this morning. Now, a two-day Women in Water conference aimed at finding innovative ways to use water to fight poverty is underway in White River, Mpumalanga. The conference organised by the Inkomati Usutu Catchment Management Agency is managing water distribution along the Inkomati River that runs in the eastern highveld of Mpumalanga into Swaziland and Mozambique. Women from different sectors such as water treatment plants, female farmers are among others attending this conference. Now, to discuss this matter further, we are joined by the chairperson of the Inkomati Usutu Catchment Management Agency, Patience Nyakane Maluka. A very good morning to you, ma'am. Thank you for joining us.
Good morning, sir, and thanks for having me.
Please tell us, ma'am, what is the focus of this conference of yours?
The focus is, the first thing is that we are faced with drought currently in South Africa. And because we know that women are the people who are on the forefront when it comes to water-related issues, right from the homesteads, they are the ones who are in the forefront. So we decided to come up with this conference so that we can come up with innovative solutions. It can be professional or indigenous ways of trying to resolve these issues, and also social and economic issues.
How do you hope to get women to contribute in managing water better?
We are hoping that from this conference, because the women are going to exchange knowledges, right from the conference when they go back home, they are going to teach other people, and the word is going to spread. Most of the things that we are talking about are issues such as when we adopt a river where we are staying, by cleaning the river, getting rid of everything that is unwanted. A lot of people these days have got a tendency of taking baby diapers and throw them into the rivers, and the clothes that they're no longer wearing, even the weaves that the women are putting on their heads. So these are the things that we teach them, and even to indicate to them that all leaks should be closed. And right now, we are planning on coming up with water forums in all the wards in the entire catchment area of Inkomati Usutu.
Tell me about these resolutions. How are you going to implement them in the wards, as you say? What will that process look like?
We are going to partner with the municipalities, those who are within our catchment area. We are going to talk to the mayors, the MMCs, as well as the ward councillors, just to help us partner and indicate and also to teach the people in the entire catchment area, more especially the women, be it farmers, be it subsistence farmers, be it commercial farmers, and from all walks of life.
Now, your message. We know that women are always most at risk when it comes to matters of the environment, but what's your message in general to the women in your area, but also elsewhere in South Africa who are battling the drought?
My message will be that in the entire world, we've got 72%, which is water. And out of the 72%, 71% is salt water. We only have 1% being fresh water that we can use. So we need to use water wisely, the little water that we have, because South Africa is one of the driest country. We are a water scarce country. In the world, we are ranked as number 30. And also the fact that in the past 30 years, this is the first time that we are encountering this kind of drought. So we need to use water wisely, and also our wetlands, we need to take care of them.
Ma'am, I thank you for joining us today. That is the chairperson of the Nkomati Usutu Catchment Management Agency down in Nelspruit, Patience Nyakane Maluka, and they're working with women to find innovative ways to deal with the situation that is afflicting the entire province, but most of southern or the northern parts of southern Africa, as it were. We're staying on the theme of water and drought. The Northwest Department of Agriculture and Rural Development says the current drought started way back in 2002-03. The department says the impact of climate change has affected the province, resulting in vegetation or crop failure that has affected livestock as well. Currently, the inability of the province to meet the demand for water has multiple and has had negative impacts, both in terms of the natural environment, but will also affect job losses. The province, together with the Free State, KwaZulu-Natal and Limpopo, were hence declared disaster areas. At the recent provincial dialogue, various strategies were discussed to lessen the impact both on people and the environment. Now, the Northwest MEC for Agriculture and Rural Development, Mankete Tlape, joins us in our studio there to give us an idea of how these matters are being mitigated. A very good morning to you. Thank you for joining us.
Thanks, Mr. Jensen, and thanks to the viewers.
I'd like to ask you, ma'am, I know that the entire province has been afflicted and affected by harsh drought conditions, but just give us a quick overview as to where you are now.
In fact, we started in May, where we convened a drought dialogue. We met with our farmers throughout the province. We met with organized agriculture. We met with the banks, insurance companies, where we were saying, even where in the presence of Agricultural Research Council, where we were saying to our farmers, we are hard hit by drought as the Northwest. The Premier was there, the Deputy Minister of Agriculture, Honorable Becky Cele, was there. We said we need to start preparing ourselves psychologically and otherwise, because no matter the situation we find ourselves in, we have to produce, people must eat. And in that dialogue, we agreed as the Northwest with our farmers that we must make an analysis where we issued out forms, where our farmers were filling up forms and say who are in need of assistance. The Premier then declared a drought dialogue disaster in July, and we have submitted everything procedurally with national. But amongst our programs, we went back and reviewed what we were doing in the Northwest. For crop farmers, we made sure that our programs talks to the situation at hand. We issued mechanization, assisted our farmers with mechanization, that is tractors, implements. We also assisted our farmers with inputs, those that qualifies in any way. For livestock farmers, we have just after the national department said we can reprioritize our grants and assist our livestock farmers with fodder. We have already started issuing that, and we found within our coffers, out of whatever we have spent, because our budget, we spend about 97%. We could find 25 million that we have bought fodder that we have been distributing to our livestock farmers.
Now, ma'am, just give us a quick idea. We've seen some rains in the area in the last weeks, not a lot of it, but has it made the situation a little bit better?
Our prayer is that there should be improvement, especially for livestock, because these sporadic rains will make sure that there's improvement, there's grass, it becomes green. But we are mindful that for crops, the planting season for maize, for an example, was mid-November. Our best bet will be plantation of sunflower. But we are very much hopeful that the situation will be alleviated, especially for livestock. There will be grazing. Grazing is definitely going to improve.
Now, the Northwest Province is largely a rural province. We understand that there's help and helping hands been extended to farmers and so forth. But how difficult is it for these farmers in the rural areas to access?
The issue of access is not a problem as such, because in every locality, every municipality, we're having our offices, we're having extension officers. That is why even for distribution of fodder, we made sure that we have teams that goes to every district, to every locality. The only problem is that as and when we were registering for assistance, situation was not worse as it is. And most of our farmers are saying now to us, I did not register then, or I did not have information. But we have indicated to them, this is just a provincial strategy, a provincial way of assisting. We are still awaiting the National Department to assist us, like you rightfully indicated. Northwest is one of the 5 provinces that has been declared disaster. We have said during our Farmers Road Show throughout the districts of the province, National is going to assist us, we know, because it is their competency. As the province, we no longer have that contingency plans, because that is what created under expenditure. But we are very lucky because the departmental minister nationally said, reprioritize, put on hold projects that you can, and assist farmers where you can. And on top of what we are distributing now, when National come to assistance, we'll go to all these ones that are saying, I did not register, I was better off then, or I did not have the opportunity to register, and make sure that everybody else is covered.
And you've got 30 seconds to tell me, ma'am, what's your message then to the farmers, ordinary citizens, but also municipalities there?
As much as we have been out together with the Premier, praying and talking to farmers about this issue, that where you can, please reduce your livestock. You can sell now, put the money aside, and make sure that as and when the situation improves, that is the way to go. We must also make sure that we preserve water as a province. We must also make sure that we have what it takes, like the livestock, the number that we have. But we are saying we are here to offer support. Those that we have still not got into, they can still contact us on the numbers that we have issued as a province and say, you can go through us, this is the situation, and we'll definitely make sure that we touch every area in this province for assistance.
Thank you very much for joining us today. That's the Northwest MEC for Agriculture and Rural Development, Manketsi Tlape, joining us live there from Mahikeng. Time for us to take a break. When we come back, Kendall Makamati will give you a little bit more detail on Heineke Meyer, who stepped down as a Springbok coach.
Get all the latest news from the SABC's online news services on our website. Breaking news and in-depth coverage of everything from business, sports to politics and lifestyle. Catch the top news clips and watch live streaming of major news events on the SABC News YouTube channel whenever. Stay connected on the SABC News Facebook page and have your say on news that matters to you. And for the latest headlines and live updates from our reporters, follow us on Twitter. SABC Digital News, anytime, anywhere.
Good morning and welcome back. I'm Kendall Makhamat and I've got your sports on Newsroom. Now, as you've just heard a little earlier today, we've got breaking news that we're bringing to you live right here from SABC DSTV 404. Now, Hanneke Meyer has quit as Springbok rugby coach. Following a meeting with South African Rugby Union President Oregon Hoskins and CEO Yuri Roo, he advised Saru that he no longer wished to be considered as a candidate to coach the Springboks. It was a decision he considered to be in the best interests of South African rugby, following recent developments. He was severely criticised for the Springboks' predictable and bland game plan at the recent World Cup, where the team finished third. Meyer took over as Springbok coach at the conclusion of the 2011 Rugby World Cup and coached the team to 34 victories and 2 draws in 50 matches. Now, let's take a quick look at some of the comments that came in following this sudden announcement. Now, as you can see, young Caesar was quick to fire. Today's turning out to be a good day, he says. Oscar guilty and Hanneke Meyer quits. Happy Thursday, Hanneke Meyer quits. Now, Lono Abomiso, Hanneke Meyer decided to stand aside as coach, a decision he considers to be in the best interest of South African rugby. Interesting that. Stefan Stringer. So, Hanneke Meyer quits from coaching Springboks. Wonder who'll have to repair this broken team now. Yes, very interesting that. We'll be finding out shortly from Venon Klaasen. We'll be chatting to him shortly, who he thinks should be repairing this broken team. Musiburi Rachel, it's not even midday. Oscar Pistorius and Hanneke Meyer. Yeah, it's a very big Thursday in the world of sports and the world of news in general. And those are the tweets that have come out, the first couple of tweets that came out about this particular topic. Now, for more on this story, we now joined on the line by former Springbok captain Venon Klaasen. Good morning, Venon, and how do you do, sir?
Good morning, and I'm fine. And you?
Very good. Very interesting news that's come out. What do you make of this story that Hanneke Meyer has resigned? What does it mean for the Springboks?
Yeah, I first would like to say I think it's an honourable thing to do. We must applaud Hanneke for doing that. I mean, couldn't have been an easy decision, but I think he made the right decision because I mean, if you look at his record, it wasn't so great this year with the World Cup and the last year, and the way we've played and selection, a lot of factors. But I think it's the right thing to do. But now we must look forward, and I think it's it's important to appoint the correct coach or the right coach. I'm sure they would know who they want, but I think we must go back to basics. And it's not only the coach. I think that's also important is that the assistant coaches. I think that's one of the problems that Hanneke had. The guys that he appointed himself was very inexperienced on an international level. So I think it's important that whoever SA Rugby appoint, that they also appoint quite strong, knowledgeable assistant coaches with a lot of experience.
Please tell us, Venon Klaasen, the Hanneke Must Fall campaign that you and Divan Serfontein got involved with, what do you make of how important was that in getting Hanneke to make this decision?
Well, I think, I think it did play a major role. I think it started the debate. Basically, we started the campaign when that he has already signed a new contract even before the World Cup, and that was quite astonishingly, and a lot of supporters, a lot of former Springboks, and a lot of ex-players, provincial players, everybody asked us, how can that happen? What can we do about it? And that's when Divan and myself decided we must query this and question this, and so I'm sure it played a major role, and it just shows that ex-players in the country, former Springboks, and also the supporters, the people that pay at the gate, people that support the Springboks that fly over to the World Cup and they buy the jerseys. I mean, they're also knowledgeable, they know the game, and everybody was concerned about the way the Springboks played, and so I think it started our campaign started the debate, and it started, opening up, that everybody start, that there is a way or a method that people could ask questions.
Venan, some people from the comments that I read just before you got on the line with us is that this is a broken ship, and who's going to be next in line to fix this broken ship? Have you got any idea who the top prospects might be?
No, I don't know who is a rugby, who they're talking to, who they're considering. We, in our document that we sent through yesterday, our report, our final report on the response that we got from all the ex-Springboks and ex-players and supporters, all the support that we sent through. And we made some recommendations there that we basically said that I think we will go back to basics to coaches, and that was Devon and myself and a few others' recommendation that those coaches must at least have played rugby at a very high level, and our recommendation was that it should be a guy like, maybe the head coach, a guy like Alistair Coetzee that played top rugby, coached for a long time, as assistant coach to Jake White when they won the World Cup. And then as assistants, get strong guys like Jan Ackerman. The way, we saw how the Lions, how well they performed, and also a guy like Franco Smith that also played Springbok. He was coached internationally in Italy for a long time. And he did wonders with the Coffees this year, the Shimlers this year in the World Cup.
And in closing, Vernon, thanks very much for bringing through Alistair Coetzee, because his name has been bandied around quite a lot in media, most recently as a possible front runner. Would you be able to put your head in the block and say, look, there's a specific brand of rugby that you've seen out there, or maybe a hybrid of rugby that you've seen out there that you say should be played by the Springboks to stop it from being bland?
Yeah, I think we've got to move on with Springbok rugby. We've got such a lot of talent in this country. If you just look at our schoolboys, and Craven Week, and at all levels, we've got fantastic talent and fantastic players, and we became one-dimensional team playing for the Springboks. And if you look how the rest of the world is playing, all following the All Blacks, even Japan and Argentina, and everybody is moving on and playing a better brand of rugby. And if you just look at the way the Lions have played the last 2, 3, 4 years, they don't neglect their scrumming or the tight phases or line-outs and the driving. But they also back themselves up by playing a bit more expansive game. And I know you can't play that all the time. Sometimes you got to kick. But we got to, previously Springboks did play like that. And we've got enough talent that we can play that brand with strong forwards and good backline, because we've got brilliant backline players. To just look at guys like Errol Tobias when they played, and the Danish Harvard and things like that. There's a lot of talent. So I think we must move on and put Springbok rugby right at the top again where we should be.
Mr. Klaasen, thank you very much for joining us and shedding some light on where to now for SARU and the Springboks. We appreciate your time.
Thank you very much.
That was Venan Klaasen, the former captain of the Springboks, and also one of the founders of the hashtag Hanneke Must Fall campaigns. Now, moving on to other news that broke earlier this morning, law enforcement officials in Zurich have confirmed the arrest this morning of 2 more FIFA officials. The arrests are believed to be part of the ongoing investigation of soccer's world governing body, FIFA. Those arrested are suspected of accepting bribes of millions of dollars. The arrest happened during a pre-dawn raid on a hotel in Zurich. Swiss authorities have not named the officials, but have confirmed they're being held pending extradition to the United States. It's believed the U.S. has indicted up to 16 people today, but not all of them are currently in Zurich, where FIFA officials were due to attend a presentation on planned reforms. Authorities are targeting current and former senior soccer officials on charges that included racketeering, money laundering, and fraud. Now, with nothing to lose except maybe another toss, the Proteas rung up the changes in the side to face India in the last test of their already lost series. Temba Bavuma comes in for Stian van Zyl at the top of the batting order. Carl Abbott is in for Kagiso Rabada, and what's proved to be an inspired choice, Dane Piet is in for Simon Harmer. Now, restricting the Indian host to a low run rate, South Africa's bowlers started off very well. Best of all, though, was Dane Piet, who's taken 2 for 42, who had early on taken 2 for 42, leaking just 3 runs per over. He took 1 wicket before lunch and 1 just after. Abbott then bowled Pujara out just before the end of the 30th over, and India had been holding steady since, trying to recover from the early setbacks. And then Dane Pete struck again, as Bavuma and Villa showed great match awareness to dismiss India captain Virat Kohli on 44. Now, we'll bring you an update of that score a little later before we're done with this bulletin, so make sure you stick around for that. And South Africa's Xander Lombard is the early leader following a tough opening round at the Australian PGA Championship on the Gold Coast. Lombard finished on 5 under par 77, 2 shots clear of England's Mark Foster in very windy conditions at the Royal Pines Resort. Another South African, Dylan Fratelli, carded 3 birdies and a bogey for his 2 under par 70. He's joined 3rd place with Australian Ashley Hall. But the tournament's highest-ranked player, 7-time PGA Tour champion, Brandt Snedeker, had a nightmare day. The American struggled to a 12 over par 84. His round included a triple bogey, a double bogey, and 8 bogeys. 4-time PGA Tour winner, Australian Robert Allenby, had to settle for 4 over par after carding 6 bogeys and just 2 birdies. And lastly but not least, South African Andy Marinos, who's been appointed as CEO of the Southern Hemisphere Rugby governing body SANZA, believes the expanded Super Rugby format will be a success. Teams from Argentina and Japan join the EP Kings in next season's tournament. 43-year-old Marinos has been part of the South African Rugby Union for the past 5 years, where he was serving as the General Manager of Commercial and Marketing. As a player, Marinos represented Wales as well as Western Province, Stormers and South African Sevens.
The South African brings a wealth of business and rugby experience to his new role. He has served SARU as an acting managing director and board member, as a Springbok team manager, and has had many wonderful memories.
Unquestionably would be the 2007 Rugby World Cup. It was a very special time being really involved with the team, the British and Irish Lions series, and I think also then the growth and the development of the Sevens. I was very involved with Paul at the inception of getting a professional base, moving it to Stellenbosch, and I think then seeing them win in 2009 has to be also a big highlight. And then finally that magical 2009 year where I think we owned every single trophy available in World Rugby other than the Sevens World Cup. So there's been many special moments here.
Besides Marinos' rugby career in South Africa with Western Province and the Stormers, he earned 8 test caps for Wales. He also played rugby league for the Sydney Bulldogs. With the lure of the pound, euro and yen, SA Rugby is losing players at an alarming rate, and Marinos feels drastic action needs to be taken.
We can't underestimate the strength of our domestic structures. Our school system feeds in. It's about nurturing and harnessing that talent. From a national point of view, I think we've got to put more pride back into the jersey and probably put more rules around the eligibility to play for your country, rather looking internally before you look externally. Otherwise, I think the attrition is just going to continue.
As SANZA CEO, Marinos' first goal will be to make the new Super Rugby format with 18 teams a success, something he is excited about.
Argentina, I don't see any problem at all. They're a proper outfit, and the core of that team that played in the World Cup is going to be strapping up and playing in the Super Rugby franchise. So there's a big tick and I think a big worry for a lot of the franchises. The Sunwolves has been a little bit more difficult, losing Eddie Jones and then him coming here, then moving on again. So that's been a bit disruptive. And also they've had quite a few players that have moved on and retired. But they've got a core group of good players. Their biggest challenge at the moment now is just securing a coach for Super Rugby.
Marinos is also confident that the problems experienced by the Kings are under control since SARU have stepped in.
The Kings isn't really much of a worry now that we have South African Rugby having stepped in and knowing the calibre of the people that are going to be involved. You look at Rassie and his high-performance unit. I think all the on-field issues are going to be properly addressed, and then the other GMs in SA Rugby are getting involved in the off-field issues. So I think there's a big enough safety net around that to make sure that it's sustainable and competitive.
Another concern Marinos has for South African rugby is the development of coaches. There's a lack of mentoring and growing of young coaches, and they often don't get the necessary support and get lost in the system.
The talent is certainly here, and we've got talented coaches, but a lot of the time they don't have the people that they can tap into who have been there, had that experience to help them through difficult situations as and when they do arise.
A dedicated family man, the 43-year-old has a passion for surfing. He currently resides in Stellenbosch and is married with 6 children. He starts his job at SANZA on the 1st of January. Craig Murray, SABC News, Cape Town.
Now, of course, when that was recorded, Andy Marinos had not heard about Hanneke Meyer resigning yet, and that's probably why he had no comment on it just yet. So, but would you have comments on other stuff?
No, I think they would have known for most of the last week that Hanneke was going to step down. I think ahead of next week Friday's meeting, the 11th of December, I think it would have been put to him that chances were very likely that he was going to be asked to step down anyhow. I think the SARU board. I think the EXCO were going to vote him out anyhow. Sure. He's now done the honourable thing by stepping down, but I don't think he's been given much of a choice, to be honest.
Well, it tells you a lot what a hashtag can do for you. Hashtag Hanneke must fall.
Yeah.
It came down.
I think that was in this case, the important thing that stood out for me was that it was former Springbok captains and pretty much the boys' club that turned against him. Which doesn't happen very often in rugby. But lots of comments, of course, coming in with regards to Hanneke and Oscar today.
Yeah. The first one is golden. Just because you're famous and have money does not mean you can get away with murder. Finally, justice for Riva, justice for women.
Golden there. This one from Eamon O'Reilly says, SABC Newsroom, justice at last for Riva.
Temba talks about, yes, he has to be sent back to where murders are kept. Murderers, I would think, Temba.
And Rob Armstrong says, wish Hanneke Meyer all the very best and always admire his unfailing passion and commitment for the Bokke and for South Africa.
This is Rob. Simon says, justice is done. He must get a life sentence and let it be a lesson to rich people that they can pay. No,
they cannot pay their
way out. That's the one that we've got there for you.
All the best, Hanneke Meyer. Thanks for what you did for SA Rugby over the past 4 years. Yes, there's the end of the line for Hanneke Meyer. Not yet the end of the line for Oscar, but it's definitely the end of the line for us here in the Newsroom studio. We'll be back again tomorrow, Friday, with more.
That's all from me, Elvis Preslin.
And me, Kendall Makamate.
Evan Jansen. See you tomorrow.